for a parking problem.
Or in your 23.
Yes, we're over the 28 from my truck when you're ready.
Go ahead.
My truck, white Lincoln X-ray 985, should come back up next.
So you had 2000 Patrick Spalding.
10-4. If you can put a little note in something like that, I'm going to be leaving a note on a vehicle so that I can go remove it.
Rockingham 505. For Athens, complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Forgive that to 32.
10-4. 532, you're assigned to a vandalism case in Athens. Can you copy the 505?
Yeah, 4. Look at that. No, 3 and Depot Street. Truck 2835.
143.
You go with that 43 you had. I didn't hear any, but that just looks like we do.
10-4, I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that found property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449, 1120.
Now 449, 1121, thank you.
10-4.
Code 4. 4.
Roadway 535.
You have a great coach.
535.
Should be. You guys know if I'm going to fuck into my house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get it down. About 5 foot, long dark hair, got tight shirt on. Number 21 is on.
Switch is on, here comes the throttle. Circuit breaker's in. We have separation. Inboard Boards are on. Coming forward with the sightseeing. I've got a blowout. Neighbor 3. Introduce to 0. Edges out. I can't hold altitude. Correction. Alpha 4 is off. Try flight with emergency. Flight call. I can't hold it. She's breaking up. She's breaking.
Ladies and gentlemen, we are at war. At least if you are in the state of Massachusetts, we're now at war with the federal government. This is an amazing day. This is a case that is definitely going to be taught in law schools for decades. It's huge. We are at war. Judge Canone is at war with the U.S. Attorney's Office. So if Massachusetts is at war with the federal government, I guess that puts us in line with Texas and many other states, Florida. But this is amazing. So this has been a huge document dump today. Many of them I've read, many of them I have not had time to, and I have not had time to organize this in any way. Actually, I don't need these unless a guest comes on. So let me take this off. So I'm going to go through some of the stuff that I've seen already. Be a little patient, and then we'll actually open some of these things just live on the air, and I won't even necessarily know what they are until I open them. I do have an idea what's in most of the things, but it just hasn't been organized yet. But let me open up the declaration of war first, because this is amazing stuff. All right. So this came to the judge today from the U.S. Attorney. Now, before I go over this, I just want to set the table a little bit for people. And let me just check and make sure my mic is working and everything, and say hi to everybody. So, Mousy Swift, you were the first to comment. We should have a prize for that. Whoever's first to comment every night gets a prize. Retired Lieutenant said, keep up the good work. Appreciate it. Had a lot of really heartfelt and appreciative emails today. They come in spurts, these kind of things. Obviously, I get a lot of hate messages and stuff like that, but some very heartwarming messages, and almost all of them say the same thing, and that they wish they could do more because of the mob. And that is Aidenism at its heart. That's what's been created here, is this mob that silences people. To not understand that is to not be realistic about this case, or about what he is, or about what they are. That's what they are. It's what they do. So Daniel Donovan says, I am suspecting that Karen will enter a plea in the case very soon if there's a bombshell today. Well, I'm not sure if I have that kind of a bombshell for you today, but I do think that that might be coming soon, but we'll see. My sources do not tell me of any indication that plea negotiations are underway. So whatever that's worth. But I mean, I don't think that's really surprising. I think if there are to be plea negotiations, and I've said this since last August, that they would be last minute, because it's just like any negotiation. In fact, if you've been on jury duty, a lot of times you might see that these negotiations are going on, and you show up, and they may make you wait there a couple hours. That's because negotiations are going on to the last second all the time. 95% of criminal cases end up in plea. Now, of course, that's a little deceiving, because I was not able to find what the percentage is on murder cases. So obviously most cases involve minor charges, and it's easier just to get a plea. But still, plea is a very common thing. It's generally in everybody's interest to avoid a trial if the truth can be agreed on. And I think everybody knows the truth here. But Colin, good to see you. Colin is a great example too, because Colin is kind of like me. He's up in Canada, but he's a Canadian version of me. He's been in various points of the map on this case during the last year, and he's also proposed some theories on what happened at the accident. His theories are different than mine, and I think we're prompted to promote these theories because it has to be admitted that at this point, trying to match up the injuries, which we don't really know the extent of what they are, but trying to match them up with the damage to the car is a challenge. Right now, we have not seen the medical examiner's report, so we have very limited information on that. What's little has been included by the state, and some descriptions given by the defense. So we really don't know. So it is a challenge, the puzzle for us to riddle that out, and Colin has put some efforts into it. Lori, good to see you. Tom, thanks for being here as always. Heather, nice to see you. Joey, always, man, good to see you, brother. Let's see. Kathy McCarthy says if she gets a plea deal, it has to require her to tell what she did. Yeah, I think that's called allocuting, right? And yep, absolutely. You can't just, I don't think the court will accept a plea deal that does not involve her allocuting and explaining what she knew and when she knew it. I think that would, if the, my understanding is that the court is not even open to a plea at this point. Now, I think at some point they should be, right? But they feel like they have such a strong case, and they're really angry about the way this has been, the defense has conducted itself, that they just are not even receptive to the idea of a plea. They're ready for trial. They want to go. That's what I'm getting from multiple sources. Jason says every time need to stop with the bombshells. I hear you. It is, it is actually. I even thought about that because I was putting this together last second, but I did end up thinking like, Jesus, you can't always have a bombshell every day. You know, it's like I follow AI news too, and AI developments has been a lot in the last couple of years. But there's one channel that's really good, but it's like every week groundbreaking, you know, developments in AI news, and it gets me like, all right, you know. But there were bombshells today. To me, they're bombshells. So we'll go over them, and you can now. When I say bombshells, I don't mean it's like a confession or a video of you know, the accident or something like that. You know, I don't mean that, but this is really, really, these are bombshells. Like I said, this is a case that's going to be studied. I think there are going to be whole semesters on this case in law schools for decades. It's crazy. This is unprecedented stuff. This war that's going on, even just the fact that the feds launched an investigation before the trial, a year and a half before the trial, while the state still, you know, after the state had completed the grand jury, but long before the trial, and while that whole process was underway. That's, no one seemed to know. Other attorneys did not seem to know of any examples of that happening before, because it's amazing, because just the very existence of that federal investigation influences a trial. And we're going to see that mentioned in some of the documents that come up that were put through by the prosecution. Julie, good to see you out in Indiana. Julie, some really interesting stuff on Delphi. To me, there's no doubt that Richard Allen did it, but I think there's some problems with the investigation that, in theory, could lead to reasonable doubt. Hopefully, they have more evidence. I'm hoping they have blood evidence from the car or something from the house. Chris A says Canone has been shady. At least I think you got it backwards, my friend. It's been the feds that have been shady. And this is the thing, is a lot of people here that are on the Free Karen Read side tend to be conservative and tend to be Trump supporters. And I am a moderate conservative myself. I don't really care much for the Republican Party, but I generally vote that way because I don't trust the Democrats at all. So it's been a long time since I voted for a Democrat. But one of the reasons is I don't trust what the federal government does. You have to have a federal government. I'm not one of those guys living out in the woods saying, get rid of the feds. No. But the federal government is listen, you can have corruption at any level of government or in any human organization. But the feds, as you're seeing the way they're operating here, they seem unaccountable to everybody else. They're arrogant. They're extremely powerful. Those are the type of things that draw corruption. With the fact that when you're unaccountable to anybody else, that's what leads to corruption. And you've seen the way the feds have dealt with this whole case here. They refused the letters from DA Morrissey for a year. They refused to send anybody to Judge Canone's court and explain what they're doing and explain why they're very strangely interfering with her trial. And she now is on stronger legal ground, I think, and we'll see in this letter in a second. I think they've declared war. So to me, the feds are the problem here. But, you know, time will tell when we get all the evidence. Joey Diego says the U.S. Attorney's Office basically threatened to move the entire case to federal court. Is that what the threat is? I don't think they have the power to do that. So, you know, but I'm not a lawyer. I mean, I'm not sure what I don't know. I don't think you can move a murder case to federal court. They don't have that kind of power. We have what's called dual sovereignty in this case. But I'll keep that in mind, Joey. And I'm about to read that letter, and maybe we can find out some research on it. Turtle Slayer, good to see you, bro. Or possibly a woman, I don't know. Pat, good to see you, my friend. As always, thank you. Eldon is here to entertain us. Mike from Shamrock Sports is my friend. Mike is sick of Bombshell too. I'm sorry, Mike. I apologize. It is overused, but this is big stuff today. So, Coffee Kristen, good to see you. Fiona, always good to see you. Thank you, guys. Mel said they were waiting. Well, we're here. I'm here. And I wish that I was a criminal lawyer or a constitutional scholar, because these are the kind of issues we're looking at here. And I wish I could bring you that kind of analysis, but that kind of stuff seems to be really sparse out there. There are some national shows that are discussing this case, but they don't seem to be digging very deeply. One person, Lawyer Lee, has taken on this case, but again, not too deeply, but I do find her to be very credible and interesting. I've seen that I don't know, hopefully she has nothing scheduled last night or tonight on it. So I don't know. I'm hoping she's looking at these documents. Chrome Doll, I'm back and listening. Elaine, good to see you. Emily Suzanne from down in Tennessee. People are freaking out that the kids are going to testify. EC says one man's bombshell is another man's dud. Well, let's go over it and let's see. Chris Weber says the bombshells are just to get people to click. All right, but we'll see. All right, we're going to go over this and you will see. All right, so let's get to it. Again, just to refresh. So yesterday, the Boston Globe filed a motion wanting to get some of the materials that involve the federal materials. Now, the federal materials that were handed over as a result of their extensive investigation, including a grand jury that met for over a year, those notes went to both sides, the prosecutors and the defense teams, but they had to sign a protective order, and that protective order bound them to the very strict terms within that to being able to how they would use or reveal this. Now, especially something like grand jury testimony is always considered sacred. You cannot reveal that until a trial. And if there are not indictments, it's supposed to be never revealed to anybody. So, and there have not been indictments here. So there's a lot of controversy involved with that. But Judge Canone made clear in court yesterday that none of this stuff applied to her. And she asked the sides, is there any precedent or any law that establishes that I, meaning her, am bound by this protective order? And everybody seemed to agree no. Now, keep in mind, the defense did not send anybody. But once again, the U.S. Attorney's Office was invited, and they sent nobody. And so they've failed to send anybody to any of these hearings, all right, because they don't want to face questions. Just one of so many signs of the shady shit that the federal government did here and is doing. So now that they were shocked. Oh, there's a new message coming in. So, we got a new. All right, so I'm going to be getting new documents coming in as we go. So I'm going to download this one and line it up. And all right. So this is a show that's really going to be on ad-libbing on the fly because there's so much to go over here. All right. So anyways, Judge Canone made clear that this protective order, she was not bound to it. So she can release that material. That doesn't mean she's just going to go crazy and start releasing things. So the prosecutor said, well, we don't think that grand jury should be released. The judge agreed with that. So what the judge ordered her to do was, so what the Globe seems to have applied for, and I don't have an actual, I have never got a copy of that motion. Hopefully that's in the stash that I got today. But they seem to have actually been looking for the motion to dismiss filed by the defense and then the opposition to that motion filed by the prosecution. So they weren't going after the federal documents directly. However, in those motions, a lot of that material was based on the federal documents, and they would have quoted it, and we're told there were attachments to it too. So we don't know what's in. Now, that has not been released yet today. And we'll see why, because the feds don't want it released. So that's the thing. The judge had ordered that by 11 o'clock this morning, the prosecution provide these two documents, the motion to dismiss from the defense and the rebuttal, the opposition to that motion from the prosecution, with the redactions of just the grand jury stuff, any grand jury testimony. So there's going to be a lot of other interesting stuff in that. And that only touch on what's in the federal documents, but still there was going to be a lot in that. And she was going to make it public. Now we'll see if she actually still does. But this was the amazing reply by the feds, who have essentially declared war. Dear Judge Canone, in light of the hearing held yesterday on the motion of Boston Globe Media Partners to terminate or modify the impoundment orders in the above referenced matter, I write on behalf of the United States to make 3 points. The first point we want to make is fuck you, we're the federal government. No, sorry, I shouldn't have said that. Apologize for the swear. And I'm just kidding. First, the United States believes the court, in analyzing these issues, would benefit greatly from reviewing the order entered in the United States District Court for the District of Massachusetts. So basically saying, the judge is saying, this order has nothing to do with me, but they're saying you better read it. As the court is aware, and the court, they left a "the" in there, so even the feds can't need grammar check. As the court is aware, the protective order governs disclosure of materials produced by the United States Attorney's Office in response to the parties' January 18th joint request under the Department of Justice's TUI regulations. So those are when one agency has evidence that is relevant to a case going on in another agency, another part of the government, another branch of the government. And so they have to go through this process, and then it has to be shared. The protective order explains, among other things, the reasons that sealing of the materials is required and how the parties may use the confidential materials at the upcoming trial. Again, that's kind of bad grammar, but I guess Josh Levy missed that day at school. Indeed, it may be the case that some of the confidential materials may be disclosed at the trial in a manner that is entirely consistent with the protective order. So as they said, it can be disclosed at trial. But as you're going to see here, I don't think the judge wants any of this in trial. And certainly we're going to see that the prosecution doesn't want any of this at trial. And we'll see what the judge rules. But I think there's a pretty good chance that she will agree with that. While the United States understands that the court has not yet received a copy of the protective order from the parties, we understand that one of the parties will be filing the protective order with the court today. So I wonder what party is that? Again, so let me just repeat this here, because this is just mind-blowing, right? So this protective order that binds the defense and the prosecution, apparently no copy was ever sent to the judge. And they're saying here, we understand that the judge has not ever received a copy of that protective order. But it says, we understand that one of the parties will be filing the protective order with the court today. Gee, I wonder which party that is. There's two parties that have the order, the prosecution and the defense. And all we've ever seen in this case is that the U.S. Attorney's Office refuses to answer any letters from the prosecution, from the DA's office, refuses to tell them anything what they're up to. Anything. It's just, we're the feds. We get to do what we want. So I'm going to guess that they're having yet more inappropriate communication with the defense. Why is the defense want to send this protective? Now, I'm assuming here, so I don't know. But why would the defense want to share this at the instruction of the U.S. Attorney's Office? Why would they want to share that with the court? I think you could say because the defense doesn't want this stuff released. But, time will tell. To the extent the court does not receive a copy, let me scroll over and scroll up. The United States suggests that the court order one or both of the parties to file it under seal as soon as possible. So somebody told the feds, we're going to be getting this soon. We're going to be sending over to the court the copy soon. But in case that doesn't happen, they're saying we suggest you order them to give it to them. This is just so weird. Second, with respect to two of the memoranda that are the subject of the motion and the court's oral ruling on April 9th, seeking to unseal, that's yesterday's ruling, seeking to unseal those findings in some form. Specifically, I don't know what that DKT numbers, blah, blah, blah means. The United States respectfully, so that must be those, that's the two motion, that's the motion and the opposition. The United States respectfully requests that the court permit the United States to review those filings in unredacted form before the court reaches a final determination on unsealing. So the United States can assess whether disclosure is consistent with the protective order or whether the United States would seek modification of the protective order to permit further disclosure. So they won't send anybody to the judge's court. They ignore everybody. And now all of a sudden that this stuff might be released, now they want to get involved. The parties have not provided the United States with copies of the filings, giving your honors impoundment order. While the parties have notified the United States of the Bates numbers of the confidential materials referenced in the filings as required by the protective order, the Bates numbers do not provide the United States with enough context to assess whether disclosure is appropriate. It's none of your business, U.S. Attorney's Office. This is a murder trial. These are materials that are being used in a murder trial. It's up to the court. It's up to the judge in that murder trial to decide what is appropriate here. And especially given that, amazingly, they found shit. They found nothing. Okay? So they're just trying to hide and protect things. They're trying to cover their own ass. So let's continue with the last paragraph. Finally, given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and non-compliance with that order. So this is interesting. Let me just stop here to repeat that. So given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and non-compliance with that order affects a federal interest. Again, what is the federal interest here? We're going to learn as we look through these documents, there was no predication for this investigation. That's what the state is saying. And now that everybody's read this material, and well, when I say everybody, I mean both parties and the judge, I really doubt that the state is lying about that. And the feds, the judge is going to know that she's going to know. She's going to say, yeah, that's true. They just launched this basically for no reason. They had no suspect. We're going to see the specific documents on this later. They had not only no suspect, they had no crime. They had nothing that they were looking into. So what is the federal interest? I mean, if this was a case involving the release of, spy information or something like that, but there's nothing mentioned like that. There's nothing in this. So they have no basis. They have no interest. The federal government has no interest here. That's, yes, investigating corruption, that would be their interest, but they didn't find any corruption. So their real interest, of course, this isn't what they mean by that, but their real interest is covering their ass because they have egg in their face, because they interfered in a state murder investigation and came up empty, found nothing. The United States is obligated to ensure compliance with the protective order. Should the court, they're going to start threatening her. Should the court authorize the unsealing of the filings containing confidential materials in a manner that is inconsistent with the protective order in its current form, the United States may need to take appropriate action to ensure that the federal court order and its interests are adequately enforced. which could include removal of the federal court of any adverse ruling pursuant to 28 USC 1442. If somebody knows what that is in chat, please get back to me. I'm going to try to Google that now and see what that is. To be sure, the United States has no interest in that course of action, particularly over an ancillary motion that has not seemed to affect the party's ability to try this case on the court schedule. What is in their interest there? There's nothing here to hide. Okay? As you'll see, there's no evidence. The idea that the feds uncovered some conspiracy and they withheld that evidence is absurd. I don't know. Other than Sean, I don't even, know of any serious people who believe that. I don't even think Aiden believes that. The feds didn't find anything. It is what it is. So that's going to be clear from all the other documents that we go through here. So let's see if we can find out what this, let's try to go to Bing's version of ChatGPT and see if they have an answer. So this is USC 140. I don't even know what that symbol is, so I can't make it. Is that a dollar sign? Let's see. So it's 1442. All right, let's see if we get an answer from ChatGPT. This is the high-level research that goes on at Yellow Cottage Tales. All right, interesting. It did come up with an answer. It's typing it up on the screen. So give me a moment, and all right. So all right, let's are we done with that document? Okay, so let me pull that up on the screen for you. Let's bring you in, Mr. ChatGPT. All right. So USC 1442 provides a mechanism for removing certain civil actions or criminal prosecutions from state courts to the district court of the United States. So yes, I forget who it was in chat that said they're threatening to try to take this murder case out of the state court and put it in federal court, district court. Is there any, what is the precedent of that? Is there any? This is crazy. This is why I say we're at war here. This is utterly unprecedented. I don't see how the Attorney General from the DOJ is not involved at this point. It's crazy. Federal offices or agencies sued or prosecuted in relation to acts under color of office, rights, titles, or authority claimed under any act of Congress. All right, so this is where it applies. All right, so this law applies to the following scenarios. Federal offices or agencies sued. Property holders whose title is derived from such officers. Officers of the courts of the United States. Officers of either house of Congress. And specific cases involving alien plaintiffs. All right, so I guess this would be officers of the courts. So it would be a mechanism for removing certain civil actions or criminal prosecutions from state courts. But it doesn't really, so we'd have to find more information. All right, let's ask. What will be the basis of such removal? You can't just remove it because you don't like it, And I don't think it should be the case that the feds can just make a decision arbitrarily without having some reason where they can just go in and say, all right, we don't like you, Judge, so we're getting rid of you. So the basis, according to ChatGPT, is when the case involves any of the following: federal officers or agencies. Oh, that's the same thing. Let's try to rephrase this. Basis from, what would be the basis for? All right. So I asked, what would be the basis for moving a state murder trial to a district court, and is there any precedent? All right. So we are getting an answer. But this is just how bad this is. I mean, literally, the feds who've been arrogantly treating this whole case, I mean, interfering in this and acting inappropriately as agents of the defense team, are now basically saying that if you release any of this information, we're going to take over your case. I mean, that's just stunning. This is that is war. I mean, this is it's crazy. It's legal war. I'm not encouraging anybody to take up arms. No. This is not 1775. So, moving a state murder trial to a district court can occur under specific circumstances. One basis for such removal is the federal officer removal statute found in this USC 1442. This statute allows certain cases to be removed. Here are the key points. Federal officer jurisdiction. The statute applies when the case involves federal officers or agencies sued or prosecuted. The same thing. Fuck, they can't give me this is the problem with ChatGPT. Sometimes it's stupid. They keep giving you the same answer. So they're not really giving me a reason. And as far as precedent, well, there isn't a specific precedent for moving a state murder trial to a district court. Precedent in other cases involving federal officer jurisdiction informs how courts interpret and apply the statute. Courts consider whether the defendant was acting under color of law and whether a colorable federal defense exists. So, but who would decide that, right? So they're basically saying that the feds, if the judge is not following the law, can do that. Now, in that letter that came from Josh Levy, they didn't cite any law. They didn't cite any precedent. I read it out loud to you. They didn't cite anything there. They're just basically saying we signed this protective order and we have federal interests here and we demand the right to review it. But there's no case precedent that they cited. So what gives the feds power to do that? Do they I mean, is there some higher authority that they have to go to approve that? I mean, this is going to get really, really. So if the judge decides, well, the judge must be having a very sleepless night right now, because if the judge decides to go through with what she ordered yesterday, which was to get redactions on the grand jury testimony, but otherwise reveal those motions that do discuss federal material and may even have attachments related to information contained within the federal material. Then if she goes forward with that, what happens? Now, the U.S. attorney just says, sorry, we're taking this away from you. Do they actually have that power? Who would referee that? Would that go to the Supreme Court? I mean, it's does this whole case get delayed because of that? I mean, it's just stunning. So let's go to another fascinating bombshell letter. And yes, I'm sorry. To me, these are bombshells. So, you will have to put up with a little bit of my bombshell language. I don't ask for much. All right. This was, I think, item number 317 on the docket. Let's see if I can make this any bigger. It's about as big as it gets, unfortunately. So hopefully you guys can see it if you're on a big screen. The Commonwealth moves in limine to prohibit disclosure or reference to any investigations. It's worth repeating this. All right. So these in limine means these are moves that are made just before the trial for evidence or things that the jury is not allowed to hear. So the Commonwealth moves in limine to prohibit disclosure or reference to any investigations conducted by the U.S. Attorney's Office or the FBI. So the Commonwealth doesn't want anybody on the defense to even mention the existence of a federal investigation or anything that would give them the idea that there's one. So that's what the prosecution wants. So the question is that doesn't tell you anything about that investigation. If you suspect that there's this vast conspiracy, you say, well, of course they're trying to keep it silent. But the judge is not part of this conspiracy, or maybe you think that. How will she rule on this? You'll see there's plenty of other references by the judge to make it clear that there was nothing here. But so in November of 2022, the U.S. Attorney's Office impaneled a federal grand jury to investigate. This is key. November 2022, they impaneled a federal grand jury to investigate an unspecified federal crime. And as a result, extensively investigated the facts and circumstances that led to John O'Keefe's death. So it's, you'd have to talk to a lawyer, someone that works with federal grand juries. I do know someone, maybe I'll give him a call tomorrow, but is it normal to seat a grand jury and there's not a specific federal crime that you're looking at? So corruption, would be a federal crime, corruption of state troopers, local police. But apparently they just seated a grand jury without any of that. The U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target of their investigation, and no witnesses, nor the Norfolk District Attorney's Office has received notice that they are the target of an investigation. So this is an investigation where there's no targets and no crime. It's unbelievable. You have to at least state what crime you suspect happened. So on February 21st, 2024, the U.S. Attorney's Office produced the Commonwealth and defended a substantial number of confidential documents from its investigation. On March 8th and March 19th, the U.S. Attorney's Office confirmed to the Commonwealth and defense that all information, all right, so this is it. So they confirmed that all information relevant and material to the pending case against Karen Read has been produced. So for you to be out there, and I'm looking at you, Sean on the Gulf, if you still think that the feds are sitting on this stash of material that for some reason they didn't turn over to the parties, I don't know what you're basing that on, because they told both parties that that's it. They've given them everything that they have that's relevant. That's it. Now, that doesn't mean they couldn't still find something, but the idea that they're sitting on some stash, the idea that they're going to find something that they haven't found in over a year of looking, and the idea that they're all going to arrest all the McAlberts on Patriots Day. Oh, my God. What is going on with people that listen to that nonsense? I don't even understand it. So on March 19th, the defense indicated it. So here we go. On March 19th, the defense indicated that it was satisfied with the U.S. Attorney's Office representation that it had received all relevant and material information. So the defense is happy. They feel they got everything the feds had. John on the Gulf isn't happy, but the feds are happy. The defense is happy. They figure they got it all. In sum, the federal documents are consistent with the Commonwealth's theory of the case and debunk the defendant's allegations of a cover-up or third-party culprit. This is something that I've been trying to say for the last several weeks, is that it may even be the case that the defense doesn't want the existence of this federal investigation mentioned in front of a jury. And the reason is because if you're a juror and you find out that the federal government and the FBI did a massive, extensive, thorough investigation of this, and they didn't find anything wrong with the state's case, boy, that becomes inculpatory towards Karen Read. So I don't know why the defense, they wouldn't want that known. So the prosecution here asking the state, I'm sorry, the judge to disallow any mention of the federal case really protects them both. Okay. Getting a heads up that Kristen has some good questions. So I will come back to you, Coffee. I'm sorry, I can't see them because I'm trying to go over documents. And once I have a document open, I can't see what's in chat. So, but Tom has alerted me. You know I love you, Coffee Kristen. So please stay with us, and I will get to your questions and answer them in my bartender's kind of way, you know. So take it for what it is. But so in sum, all right. So well, now I was saying, so as the defense team, you know, the mention of this federal investigation, depending on who mentions it and how it's mentioned, could actually hurt the defense team. But the problem is that the reason the defense team, the reason that it's the prosecution that filed this is because the defense team is going to be shifty in the way they do it. It just, they're going to suggest it, and they're going to try to get it in front of the jury in some kind of a sly way that makes them think there was something going on there. So, but you won't be able, the prosecution won't be able to sit in front of the jury and say, yeah, there was a federal investigation. They looked hard and they found nothing. So you really, how do you discuss it fairly? And this is another part of the federal investigation that really bothers me. And this is, if you care about civil liberties, if you care about freedom in this country, all right, you ought to be suspicious about the way the federal government operates, okay? If, as this seems to be the case, Karen Read and her attorneys went in there. For whatever reason, they managed to convince Josh Levy himself that there was something to look at here. Maybe they knew Josh Levy had some personal connections, or maybe they just duped him. I don't know. But Josh Levy was able to get, because of the vast power of the federal government, the communications of anybody that Karen Read's team thought might be part of a conspiracy. So you could go on this fishing expedition and just get all their communications. Why? Because the communication companies generally don't require a subpoena or a warrant or anything like that, because whatever, for a variety of reasons, but let's just say they're afraid of the federal government, because the federal government is very powerful and can create a lot of problems for Google and Verizon and whoever. So when they get the request for the material, they give it. So obviously, so it violates your privacy and my privacy and everybody else's privacy. But they don't care, because violating privacy is the business that these communication companies are actually in. They're hoarding your data. And the last thing they want to do is piss off the federal government. And it's a lot cheaper for them, rather than have to fight it with their attorneys. They just hand it over. So, but that's a problem for us citizens, to just the fact that Karen can go into that office because she had the right pull and connections and say, hey, we want you to get those communications for all those people. And we don't know, because there's no legitimate due process here, because there's no warrants and no subpoenas, then we don't even know what they got. Because let's just say we only know what they turned over, and we're totally at their mercy. If they say they turned over everything interesting or useful, we're at their mercy. Who can look at that material? There's no process here. So, for instance, if the feds got all of the communications of Colin Albert that day, and they looked at him and they said, all right, this guy's innocent. But then they don't reveal any of that. That would do tremendous damage to the conspiracy theory, but they don't reveal it because they're only revealing stuff that they found of interest. If they got all the communications of Proctor and Kevin Albert and Brian Albert and Jen McCabe and anybody else that gets swept up in this, and that stuff turned up nothing, so therefore they just didn't turn it over, I mean, that's a problem. If they had done something like that after the trial, then maybe it's not so much of a problem. But because it's done before the trial, a trial in which this highly paid defense team with its highly paid PR agents is trying to push this crazy third-party culprit theory, that's a problem that they can do that. That's a violation of our rights. All right, let's continue with the letter. This is from the state to the judge. Through, sorry, my other computer is, all right. Throughout the course of the federal investigation, the defense communicated with the U.S. Attorney's Office and provided material and records that, defense, yeah. So throughout the course of the federal investigation, the defense communicated with the U.S. Attorney's Office and provided material and records that advanced the defendant's theory of the case. So we don't know if they gave them everything that the state had put forward into discovery, or they just gave them the stuff that they used to sell their case. This unusual collaboration, again, this is the state talking about the feds and a defense team. This unusual collaboration resulted in discovery that far exceeds the bounds permitted by the Massachusetts Rules of Criminal Procedure. Now, I don't know if that's true. I'm not a lawyer, but that would be huge. I mean, there are these rules of discovery, elaborate, and have been established over time in a way that is designed to protect the public interest, and the defendant. And so the feds are collaborating with the defense and seemingly getting material into discovery that is outside of those rules. Those rules are there for a reason. So if that's true, it really means the feds are breaking Massachusetts law. And they can't. They're not supposed to be able to do that. Just because we're the feds, no, that doesn't mean you get to do what you want. We don't live in the Soviet Union. Evidence is relevant if it has a rational tendency to prove an issue in the case. So the state is now going to outline the different things that are guidelines to what evidence is relevant and could go into discovery. So one would be rational tendency to prove an issue in the case. Evidence that is not relevant is not admissible. Therefore, the concept of relevancy has two components. Evidence must have a tendency to prove or disprove a fact. The fact must be material, revealing the mere existence of a federal grand jury. This is important too. So revealing the mere existence of a federal grand jury, particularly one that has no target, no resulting criminal charges, nor any factual evidence that would considerably undermine the Commonwealth's case, is irrelevant and has no tendency to prove any material issue, is speculative, and would confuse the jury. So this is the judge, this is the state trying to get the judge not to disallow the federal evidence, I don't think. I think, or at least in this particular motion, then there was multiple motions. This one is just to get them to not talk about. So if it's passed, the defense would never be able to mention to the jury the existence of a federal investigation. Because even just throwing that out there is going to create confusion and help the defense. Further, it would result in a trial within a trial, with much of the federal materials being inadmissible, confidential, or offered without proper foundation. This is why you don't do it this way. This is why all of the criminal lawyers that went on the record for the Boston Globe yesterday said, we've never seen anything like this. You don't do this before the trial. Should this court be inclined to allow either party to impeach a witness testimony with prior federal testimony or reference federal materials to attempt to show bias, reference should be made only to prior testimony, subject to a limiting instruction to not consider the nature of any prior testimony. The proceedings would be unfairly prejudiced if the defendant is permitted to rely upon the mere appearance and existence of a federal investigation. So that's worth it. So you're allowed to say, you're allowed to reference the testimony that took place in the federal grand jury, but what the state is saying is you just can't say that it was from the federal grand jury. All you can say is prior testimony. And this is their last sentence on this. The proceedings will be unfairly prejudiced if the defendant is permitted to rely upon the mere appearance an existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. That is huge. And I got to think that any law school teacher is going to jump on that and say, yeah, that would be a problem. And in any conception of fairness that we saw, I mean, how many people all this summer, once we heard that the feds were involved in this investigation, that really influenced how we felt about this case. I started hearing this back in last April, so a year ago. And yeah, I mean, it made it seem like there's something really shady going on here with the state's investigation. Just the very existence of a federal investigation, so unusual to look into that. So it's huge. But this federal investigation was something that was shaped and influenced by the defense. It's not something that was neutral or objective. And I don't think anybody really would say that now. So let me go to those questions and then we'll just come back to more of the documents. So let me see it. I got Tom said Coffee Kristen has some questions. So let's go through this. Christopher Weber says, Kevin, you've stayed. Oh, let me close this other document here so you can see more of my ugly mug. Kevin, you've stayed steady here while maintaining your integrity, something to be proud of, especially nowadays. Thank you. And I like I said, I do get these supporting letters and I appreciate it because obviously you get it a lot the other way. The most important thing to me is to get it right and to be fair. Those are the most important things. But the letters of support do matter too. And anything that I get wrong, I will correct as soon as I can. And that includes everything on this case. So if Sean is right and the black helicopters land in mass on Monday during the Red Sox game and Turtle Boy gets off one of the helicopters and he's holding hands with Josh Levy and they go and arrest all the McAlberts, I'll be like, all right, I got it wrong. But, I'm always going to cover the truth, whatever the truth is. If I make mistakes, it is what it is. So let's just try to get caught up. I want to go with some of Coffee's questions because I hear there's some good questions. Kathy McCarthy said, don't you think Karen's people got the feds to investigate? Yeah, all indications are. And I know that Karen has told people that's exactly how it happened. They walked into the office and that's it. So there used to be speculation this summer by Sean that the feds picked up a wiretap on some other case about something shady. No, none of that happened. None of that happened. Will, hi, good to see you. EC says vote RFK. He is an interesting candidate. So Fiona says Levy is saying she has to look at the requirements in his first letter. I mean, she's saying that I think that what Levy is saying is that she should be bound by that protective order. And she's saying, no, it has nothing to do with me. I didn't sign it. It wasn't given to me. Nothing to do with me. And there's no, just because the feds say they have an interest that they won't tell anybody what it is, they use this stuff to hide their wrongdoing all the time at the federal government. That's how they do it. All right. So Coffee says, Emily, Suzanne, of course, the kids are going to testify. Yeah, as far as I know, the nephew and niece will be testifying. Yes. Mel says Republicans and Dems eat at the same table and they all suck. Yeah, and that's the nature of politics. They all suck, but at the same time, that's the nature of politics. You're always going to have shitty choices, but that's the nature of democracy. But democracy is still better than any other system. Joey says Canone has done a great job, and I think so too. Let me try to get through these questions so I can get back to the documents. Yeah, Coffee says the feds not sending someone to argue their point, but sending a letter is bullshit. I agree. It's been arrogant and shady. It's like they don't want to answer any questions from her. I mean, they're interfering with a murder trial and they won't send anybody to her court. That's stunning. That's stunning. I mean, I know a lot of people out there have emotional attachment to everything being on the side of Karen Read. So therefore, people that used to hate the feds now suddenly don't question anything. Do you really trust the feds? I mean, they're not giving any reasons. The way they're acting, everything they've done is arrogant. Comfort and Joy says the defense knows everything, has seen all the evidence. For them to put their faith in a jury is crazy to me. But we don't know what the state is willing to deal, if they're willing to deal. If the state is willing to offer something like, for instance, getting it back down to manslaughter, aggravated manslaughter, or something like that, then you would think Karen would take that, but maybe the state's not willing to offer that. And so maybe she really feels that that her best chance is to try to sell a theory to the jury. And it may even be something more elaborate, I think it's, until we see more evidence, we can't say for sure, but just assuming, and I saw a document today, there is a full accident reconstruction theory. We don't know what it is still, but we've seen references to it in the documents today. So maybe I'll find that and come back to it. So the idea that there was no reconstruction theory put forward by the state, that's just another one of the insane things that Sean believes. But now we've seen in the documents today, if I can pull it up, no, it's there. Now, whether it convinces us, that's a whole other question. But if it's remotely convincing to us, then it's not going to be hard to get most of these jurors to understand the evidence and convict. But it only takes one. But when I say it only takes one, that doesn't mean acquittal. That means a hung jury. So you go through it again. But if you go through a hung jury and the state has to go through this whole process again, that might give the defense a little bit of leverage to work out a better plea deal. So that was 7:28. That was a while ago. So Joey, thank you. You were right, and I just get caught up to it now. So I am pretty far behind, so I'm not sure how to get caught up. But Christopher says, I just got to say it, the hole he's 12 feet hole off the curb is just not that powerful at all. He's 6 feet tall. Yeah, so we're told so maybe his feet were 6 feet off the curb. But to me, it doesn't bother me in terms of the accident reconstruction, the fact that he was far off the road, but we have to explain how the head injury occurred. And I don't think it was the case that he injured himself and then staggered around or crawled around, because the broken cocktail glass ended up with him in the grass. So I think that the collision sent him, and the force of that, I think that's wherever he landed, that's where he landed, and that's where he was found. All right, let's see if I can somehow get caught up. So Joey said something else. Let's go back to this. Joey said they're claiming they do read the end of the letter. They do, and read the end of the letter. Look up. It only works if Karen is considered working under federal office. Oh, okay. So you're saying that, huh? So I think Joey's saying that they wouldn't be able to move this trial unless Karen was working as a Fed. I don't know. We need a lawyer here, guys. Guys want to send me to law school? What's a law school take? 3 years, so it'll probably take me 5. Yeah, I got time. I'm planning on being at the next eclipse in 2030, I hear. Going to join my friend Tom Fleming and his wife in Spain or France. Amanda says the oppositions are totally available. It is the original motion set or not still, despite. I mean, I don't think we've seen the opposition to the motion to dismiss yet. So that's going to be big. But people have to dampen their expectations a little bit, because that motion to dismiss was based on an Odell, which means they're trying to reverse or dismiss the indictment by a grand jury, which is something that the government is very loath to do. And the basis of it is that the grand jury might have been shown information that was false, or the state might have neglected to show them information. And this has to be the type of information that or evidence that could have changed the result of what they voted. So that's a hard bar to overcome. So any evidence that the feds uncovered that the state couldn't have had, yes, that you will see that in trial, right? But that would not have affected the motion to dismiss because it's not something that the state had access to. So it had to be something that the state had that they neglected to show the grand jury, or that they changed or in some way like that, or lied about something significant that would have changed the way so for instance, that's why the defense was making the absurd claim that the state didn't show the information about the 227 search. The state couldn't have showed it because that result did not come up with the 2022 version of the software. They had the latest software and it just didn't produce that. A year later, a different version of the software produced a different result. But so the reason I say this is limited is so the state would not have to go out there and rebut the part about supposedly so Alan Jackson threw in that thing about the FBI having an FBI specialist in Quantico confirm the 227 search. Well, the state does not, at this point in this motion about the Odell, have to get into that. Now, they did in the court, so maybe they did, but they really don't have to, because all they have to say is we gave them what we had in 2022, and then they would settle the rest in court. So so a lot of the things that the defense might say, you don't necessarily see, just like back in this is a different issue, but back early in the case when they were talking about a gap in the library video. Lally doesn't really give an answer to it. He just says, well, you got the same video we got. But a fuller explanation will come in trial. There's just no reason for them to go into it now, so they don't. They don't want to give away the hand. Trying to get through this and get caught up. Yeah, guys, please don't forget to hit like and subscribe if you could. We're trying to hit the magic number of 5,000. When we hit 5,000, the sky will open up and rain beer. Tom told me I'm forbidding to say anything stupid and dorky and clever about subscribers, so that's the only reason I said that. Sorry, Tom. The FBI, Chowie says the FBI literally told the state they can't release shit to the Boston Globe. Literally. So you saw the word shit. I mean, you used the word literally, so you must have seen the word shit in that document. I don't think you got the same document. And the feds, we don't live in a dictatorship. We live in a nation governed by laws. And in our system, we have dual sovereignty. So it's not like the feds just get to tell the state and a state judge what to do. It's not like that. There are laws that have to be followed. I got to pat myself in the back here a little bit, though. So Foxy says, I like the levee has broken. Compliments to Grant. Oh, yeah, that's a good article. That's a good article. But I will say the first person going after the feds in this case was yours truly. So I got to give myself a little pat in the back. I mean, I put up an article almost a year ago, so last May, on suspicion of Rollins' involvement in this. But then I started really hitting this in December and January on the feds. So I'll take a little pat on the back for that. But here's the thing too about the feds: there's no accountability, and the only way for the feds the only way for there to be accountability here, and for them to come clean and talk about what predicated their investigation and what they got and didn't get and all that stuff, is if the Federal Ethics Office of the DOJ or the IG investigates it and does a report. That's it. There's no court system. There's no way the state court can make them come clean on this shit. So at the end of the day, it becomes politics. Well, The only solution then is politics. You have to create pressure on the administration in Washington to come clean on this shit. And they're not going to do that unless this really starts to get embarrassing for the feds. Now, it is embarrassing now, but this is just, I mean, there's only 723 people watching this channel right now. And so maybe a few thousand people will watch it over the next, few days. Outside of that, not too many people are really aware of the danger of what the feds are doing. And so you need to get this media coverage. And it needs to be extensive. I think hopefully, I know Netflix and other documentary makers are really hovering around town in Canton and trying to get something done on this. Well, they need to pay attention to what's going on here with the federal government and to our rights. And it doesn't matter whether they're Democrats or Republicans. If you care about your rights, you want to get to the truth here. You want to get to the bottom of why Josh Levy used the federal government in this way, allowed a defense team to use the government in a way. And if they didn't, all right, come clean. Let it all out. If you're Josh Levy and you're going to say, hey, we did everything by the book, okay, we've done no wrongdoing here, okay, come clean. We need to know everything. Start sending people to court and explaining it to the judge. No more running and ducking and hiding. All right, so I never got to Kristen's questions. I tried to look through T, but it's time to get back to the documents. So I'm going to pull all the way to the end of chat. And if she puts the question in here, we'll jump on it. We have a great group of people in chat every night. So thank you. And it's tempting to try to help out in every conversation or recognize it. It just becomes impossible. So I do the best I can. So I've jumped to the end. Daniel says this case is not that important or that interesting to Netflix. Well, they are in town signing contracts with people. So there you go. Now, I don't know what comes of it, how big the series will be, how prominent it is. Obviously, a conspiracy would sell a lot more. But this has still become an epic case in true crime, even though there is no conspiracy. So they are interested. So that's just wrong. They definitely are. They're signing contracts. Not with me, but they are signing contracts. So Joey says the USA not being accountable to anyone is so troubling. Yep. Completely agree, Joey. Yeah, I am at the. Oh, so Kevin. All right, so let's put this up. And she reads this difficultly something, so it's good differently. Kevin, it wasn't a question so much as that I read this differently. I find it hard to believe the feds could move a murder trial from mass to the feds. I don't know, yeah, I don't really know. I mean, but that's what they're threatening to do, doesn't it? Coffee? Did you read it differently? So, do you want me to open it again? Do you need a copy of this? So I'm just going to copy this. I'm not going to pull it up on the screen. It says, so this is the end of it. This is the end of the federal letter. So given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and noncompliance with that order affects a federal interest, the United States is obligated to ensure compliance with the protective order. Should the court authorize the unsealing of the filings, meaning should the judge authorize the unsealing of the filings containing confidential materials in a manner that is inconsistent with the protective order in its current form, the United States may need to take appropriate action. What action is that? They're planning to take action. That's a threat to the judge. May need to take appropriate action to ensure that the federal court order and its interests are adequately enforced. What are their interests? Which would include removal to the federal court it's so hard here because, it's very frustrating. Tom, I think you'll agree with this. I'm going to send you the grammar on this is horrible. And grammar matters because it changes the meaning of things. So I'll read that sentence again. Should the court authorize the unsealing of the filings containing the confidential materials in a manner that is inconsistent with the protective order? So should the judge violate the protective order? The United States may need to take appropriate action to ensure that the federal court order and its interests are adequately enforced, which could include removal to federal court of any adverse ruling. So it's very poorly worded, but yeah, what she said, what he is saying is that any ruling that they don't like could force the feds to take this trial and move it to federal court. That's absolutely what they're saying. That is absolutely 100% what they're saying. Which could include removal. So to ensure the federal, to take appropriate action, which could include removal to the federal court of any advantage. So it's so boldly worded because it's like, it almost sounds like they're saying they're going to remove the ruling to the court. So the grammar is so bad. I can't even believe it. I'm not sure if this is actually Josh Levy that wrote this. I mean, it's just unbelievable that a judge would write someone who is graduated, I think, second in his class at Princeton could write this poorly. It's just unbelievable. It says, to be sure, the United States has no interest in that course of action, particularly over an ancillary motion that has not seemed to affect the party's ability to try this case. So, but they made it clear there. Any adverse ruling pursuant to this USC 1442, but in that rule, I'll see if I can find a better version of it. But with the ChatGPT explanation of it, it really didn't give any parameters as to what would violate it. It was confusing. So, if somebody can find a better link to or better information about USC, so 28 USC 1442, if somebody can find something better on that, that would be really good. That would be helpful to us. I lost the comments. Oh, here we go. Yeah, adverse ruling to the protection order only. Yes, but it's going to be their interpretation of it. So if the judge who said clearly yesterday that the protective order does not apply to her, so if it doesn't apply to her, then she's ready to reveal part of this stuff that would violate the protective order if it was one of the parties, the defense or the prosecution, to do it. And she said clearly in there, it's not. Am I getting texts or tests? I'm not getting any text. My phone is right here, and the notification thing is on. You would have heard it. So I have not had a single text. This is just more of the craziness here. Just because the people on the other side can't think things through doesn't mean I can't. More often than not, the people that call me, they're asking for my opinion or my explanation than actually giving me theirs. But most of the people I talk to, we have a good give and take, and we discuss these things, and we go back and forth and decide, what possibly makes the most sense. It's back and forth, healthy discussion, as it should be. So Coffee says, to me, that's the argument, that the order doesn't apply to the judge because she didn't, and Josh is trying to say, yes, it does. Yeah, absolutely. And Kevin Mahoney is here with the answer. The Kevin Mahoney, I've used, he wrote a fantastic article that I've showed here back in September. So he's welcome to come on. If you can get him on here, I would be happy to send him the link. So I would love to shut up and let somebody smart talk. I'm going to give you guys. So this is my email. If you want to send me an email, Kevin, and I can tell that it's you, I'd be happy to send you the stream link if you're willing, and you can come on and straighten this out. I'd be much more efficient than doing it in chat. But I read your excellent article back in September. I didn't actually get it until maybe October. I think it was one one of our regulars here, Judy, that sent it to me. And I've based a lot of my understanding on what might go forth in this case on your article. So I'm not a lawyer. I'm an old bar owner. So I always prefer to have somebody that knows more about this stuff. So I will let me get the computer here to keep checking my emails in case you do decide to email, because that would be really outstanding to have you on, if you'd be willing. And I know in this case, people aren't usually willing because of the mob. Yeah, that was an excellent article. And I've referenced it many, many times. And I always say the outstanding defense attorney, Kevin J. Mahoney. So please, if you guys do need a defense attorney, call Kevin J. Mahoney of Boston. But so Charlie says, instead of shaming the feds, you have to question why they are doing what they are doing, right? Yes, but you're late. You might be a little bit late in the game, Charlie, to follow my channel. I mean, this is a year-long process, and certainly 10 or 11 months of me talking about the feds, and there's been an evolution. And I have a lot of first-hand information, for instance, from Natalie, who was talking directly to Karen. I've seen the messages. So I have a lot of information on this case. And so when I see what the state is saying about the improper aspect of the feds being involved in this, I tend to believe that, because I have never seen, there has never been any indication of what they could have predicated it on. So for instance, the feds, from the messages I've seen, Josh Levy himself was personally involved at least as far back as August of 2022. Now, at that time, there was no claims of unusual data like the 227 search. That didn't come till many months later, when Rich Green found that with the 2023 version of Celebrite software. So what could they have based it on? All they were basing it on was a thin connection between Michael Proctor and the Alberts. Michael Proctor's sister knows Julie Albert. And Julie Albert wasn't in the house. Neither was Chris. So it was, I'm not saying it wasn't a connection worth exploring, but it was thin. And if that was the only basis for launching this investigation, yeah, that is shady, dudes. That's shady. Oh, Kevin is actually commenting. So you got my email there. I actually did call your office once after reading that article to see if you were willing to talk about it. And your secretary or whoever answered the phone was very gracious, very nice. You took the message and did get back to you. So if you are willing to come on at some time, that would be fantastic. So I think there's a lot of people in here that want to see analysis from both sides, trying to be fair, trying to get to the bottom of it. And it'd be much better to have it come from a lawyer than an old bartender. But thank you very much for being here, and anything you can give us that would really help us out. I think there's a public interest in having you here. So I can tell you, I talked to a lot of people, including former FBI, people in law enforcement, stuff like that do watch the channel. So they would be really, really interested to have you come on. So, all right, man, we got so many documents to go through. And unfortunately, I'm not going to really know what's what, because I got like, I don't know, 20 or 30 documents today. So let me just start looking through some and see if I can find some interesting ones. And if I get an interesting one, I'll put it up on the screen. All right, so this one is obviously from, all right. All right, so here's one here that was defendant's motion to exclude irrelevant, inadmissible, or prejudicial prior bad character and propensity evidence. So this was about on this December 29th or December 3rd. It was basically New Year's Eve. There was a trip to Aruba, and John and Karen got in a fight there. And so the prosecution apparently is going to have some witnesses talk about that. and the defense is trying to get that removed as not relevant to the case. Those are obviously difficult things for a non-lawyer to discuss. So let's open up the next one. Alan Jackson agrees with that. All right. Like I said, sorry, you have to bear with me because these are just a lot to open up, and I don't want to be too repetitive with them. Let's see. Now comes the defendant, Karen Reed. All right, so she's got another motion for the state to comply. All right, there is some interesting stuff in here. Let me see if I can get. All right, so they talk about the Bodhi technology thing. This was the issue that I think finally they've given up on, that they just either won't be able to get usable DNA from this on time for the trial. They may not, the Bodhi Labs was not certain if they could get it, but they felt confident that they might be able to get it, but it wasn't going to be available until mid to late April. So they were going to have to delay the trial. And the judge doesn't want that. And I think at this point, it's, usually a lot of times you see the defense trying to delay the trial, and they have already up in this case here. But I think based on this, there's also an incentive for them to not want to delay it, because if you delay this trial by another month, this evidence could suddenly become available. So I'm not sure if it would be. So once the state signs the certificate to compliance, then I'm not sure if the trial gets delayed, if they're allowed to open that up and add more evidence. That would be really interesting. All right. So let's see. Thank you. I'm getting a message that this one would be interesting to open up. So let's open up one here. Again, like I said, I apologize. These were, I got like 30 motions here. All right. So let's open up this one. Told it might be interested. This one is from the state. Commonwealth moves in limine to offer evidence that the defendant was in custody for a period of time. All right, so they're trying to add this evidence. As reasons, therefore, the Commonwealth would assert that during the course of the investigation, the defendant was placed under arrest and transported to the State Police Milton Barracks, where she made certain unsolicited statements that were recorded on department-issued body-worn cams. Ooh. The Commonwealth seeks to elicit testimony in its case in chief that the defendant was at some point in custody during the time when she was observed by officers and made these statements. The fact that the defendant was in custody during this time is inextricably intertwined with the description of the events surrounding the commission of the crimes, and thus is highly relevant. So this is when she was arrested, which was a few days after. So it wasn't like she was drunk or, in any kind of a state like she was the day of the case, or recovering or hungover or anything like that. During the course of the investigation, the defendant was placed under arrest. I'm assuming this is the first time, because I think she was arrested again after the grand jury. And she was transferred to the barracks in Milton, and she made unsolicited statements that were recorded on department-issued body cams. That stuff is probably already in evidence, but I've never seen it listed on the discovery material, so I don't know. The Commonwealth seeks to elicit testimony in its case in chief that the defendant was at some point in custody during the time. So I guess I don't really understand this, except that they're probably going to enter this video evidence, and they just want to enter. They want testimony from the police officer to say that she was in custody when this was given, when this statement was made, that was picked up by the body cam. But again, I've never seen that body cam stuff listed anywhere. I don't know. Maybe I missed it. And I've read it pretty. That's interesting. The Commonwealth is entitled to present as full a picture as possible of the events surrounding the incident itself. The probative value of such observations far exceeds any prejudicial effect that it may have on the defendant. So they're saying it would be valuable. But it really depends on what's in it, right? We don't really know what's in that evidence, what she said. It seems this was, like I said, this was days after, so it's not like she confessed, right? So let's see, some of these ones. Oh, I don't think somebody has messaged me that one of these is interesting, and I don't know what's in it, but I can't find it. All right, I just got a message. All right, hold on one second. I told you this will be rough at times as I go over these documents, so thank you for being patient. You guys have my email, so people are messaging me saying this document might be good. Oh, there it is. I actually do have it. All right. I'm sorry. I didn't see it. This is docket 306. This one is from the Commonwealth. Motion to admit expert Celebrate demonstration. All right. Let's see if they say anything here. The Commonwealth intends to call digital forensic examiners Jessica Hyde and Ian Whiffen as expert witnesses. You kept hearing all in January, all this rumors in Free Karen Read Central that these guys are no longer testifying. And be like, just like everything they say is just baseless. The Commonwealth respectfully requests that during Whiffen's expert testimony, the court allow him to conduct a courtroom. Oh, this is going to be awesome. He wants to conduct a courtroom demonstration of how data was stored within Jennifer McCabe's cell phone. So he's prepared, I guess, some kind of a video thing or something, all right? Mr. Whiffen is the senior digital intelligence expert for Celebrite. Celebrite is the leading forensic data extraction software and tool that provides examiners the ability to access and analyze data stored within a device. The Celebrite software allows an examiner to parse the layers of data through different methods of extraction and analysis. McCabe provided her cell phone. Remember, that was voluntary. People forget that. She turned it, didn't have to, and she turned it over. Celebrite was used by the Commonwealth. Mr. Whiffen's expert report provided to the defendant in 2023. So Karen's had this. He utilized his superior knowledge of Celebrite software to demonstrate how, where, and when Jennifer McCabe's Google searches were stored within the digital databases. The Commonwealth moves to permit Mr. Whiffen to conduct a demonstration using the Celebrite software. Well, boy, you're never going to hear anything. I've been telling people this for a while. You're not going to hear 227 brought up in trial because, for the reasons pointed out by Kevin J. Mahoney, it's very risky to. Basically, what Kevin pointed out in his article was that the jury, even though they're not supposed to, starts out looking a little bit suspect, a little bit skeptically at the defense team. And the reason is because in most trials, the victim probably did it. And it's the defense and the prosecution doesn't really have an interest in convicting them other than that they did it. But the defense is a paid advocate that absolutely has an interest in finding a reason to dismiss them, to prove that they were innocent. So knowing this, juries just instinctively say, all right, let's kind of look at one eye to see, is this going to be a shady defense lawyer? Because in real life isn't like My Cousin Vinny. In real life, most of the time, not all the time, the accused is going to be guilty of some part of the crime, if not the whole crime that the state is trying them on. And so, but in every one of those cases, they're still going to have lawyers that insist my client didn't do it and is going to try to manufacture evidence. So they were already kind of standing there waiting for that. Just like if you walk onto a little used car lot, you're already skeptical if you have any kind of street wisdom at all. You're already thinking there, sitting there saying, all right, this guy's going to try to really sell me this vehicle. So I have to really to kind of gird myself for that, to make sure that I'm resistant to whatever bullshit he's going to send my way. So because the jury has this attitude towards defense lawyers, it's extra important that those defense lawyers don't do anything that lessens their credibility. So, for instance, if Alan Jackson goes out and tries to talk about a non-human hair again, that jury is going to tune him out for the rest of the case, because there was no non-human hair. There was, the report said no human DNA found, which just meant there wasn't enough DNA to get a match. It certainly was not a non-human hair. And so if Alan Jackson, he can point that out in a hearing now, because this is all about influencing the public. But in an actual trial, when the prosecution will stand up and say, no, that's not what it meant, this was a human hair, and this is what it really meant. So when the jury hears that, if they hear Alan Jackson do that once, twice, they're going to start to dismiss him. And the danger of that is, then if you're in a situation, she's charged with second-degree murder. So if you're in a situation where you want the jury to charge her with manslaughter but not charge her with second-degree murder, it's going to be harder to do that if they've tuned out the defense lawyers as being not credible. All right, so going on, it is within the sound discretion of the trial judge to permit a courtroom experiment. So they give all the reasons legally why he will be able to probably plug in his device onto a big screen and show how it works. And I would think that even Sean will be convinced after that. Maybe even Turtle Boy. The Commonwealth intends to have Mr. Whiffen use the highly disputed extraction report from Jennifer McCabe's cell phone to demonstrate with Cellebrite software how, where, and when the digital data of the Google searches were stored. This demonstration would closely mirror the actual Google searches conducted by McCabe on January 29th and would aid the jury in understanding how Mr. Whiffen is able to opine that the contested searches occurred at approximately 6:24 and not 2:27 a.m. And this is what Jessica Hyde had found this summer too. And Jessica Hyde is really elite. So just looking at the rest is just some examples of other cases like that. Alternatively, the Commonwealth would move to admit a video recording of the demonstration to accompany Mr. Whiffen's testimony. Again, they're giving examples, other cases. So they want to show an in-court or video demonstration that would enable the jury to understand the technical digital forensic data, as the data itself is technical and voluminous and requires an expert's explanation. So they're going to bore the pants out of this jury with that, because they have to. But I don't really, just in case the defense goes with it, but I don't think they're going to. All right, so let's open up the next one. This is like Christmas. I don't even know what I'm opening, except people are sending me messages saying open this one, and I don't know until I get there. All right. This one also comes from the state. So to balance it off, after I do this one, I will go back and try to find some of the ones from the defendant, because I do want to try to be balanced. So again, now comes the state and respectively moves. Let's see. This is about the medical treatment. All right. So to admit defendants out of court statements. All right. So to admit defendants out of court statements for purposes of medical treatment. All right. Interesting. This must have been at the hospital or possibly in the ambulance or something. So the state wants to admit records and statements of the defendant made to treating medical professionals at the hospital, as the records are certified and the statements are admissible as statements of the defendant and statements made for purposes of medical treatment. The statements are not hearsay and are admissible pursuant, citing the case, prior cases say records kept by hospitals shall be admissible. Let's see if it gives us any indication what's in this statement. During her treatment, the defendant's blood was drawn. The defendant's blood was not drawn to investigate whether she had operated a motor vehicle. All right, so the defendant's blood was not drawn to investigate whether she had operated a motor vehicle under the influence of alcohol, nor did any law enforcement officer request the defendant's blood to be drawn. At the time of her hospitalization, law enforcement was in the preliminary stage of gathering information as to what was initially reported to be an unresponsive male in the snow. When the police arrived, the defendant had not been operating a vehicle. So there you go. So why didn't they try to get her in a DUI at that time? Because she wasn't driving at that time. They didn't know that she had just recently driven, but at that point, Kerry Roberts was driving her own vehicle. Oh, and this, I mean, one of the questions that's always bothered a lot of people in this case, certainly Karen's side, and rightly so, is why didn't the Canton police secure Karen's vehicle? So I don't know. That's so they had hours to do it because Karen went by ambulance to the hospital. Then her father and her brother came and picked her up and brought her back. I think they got to John's house around 10, and they were there maybe a half hour, an hour or something like that. And then they drove to Dighton. So let's say by 10:30, 11 o'clock, up until that time, so from 6 until 10 or 11, so 4 or 5 hours, the Canton police had time to go and secure that murder weapon, and they didn't. Now, the state police were not involved yet, and the Canton police knew the state police were taking over, so they may have been a little bit not as motivated as they should be because they understood the state police were taking over. But still, it seems to me that it just should be standard that in any hit and run situation, you want to secure the vehicle as soon as possible. But I don't know if it was affected by the fact that that the vehicle wasn't there. I don't know. It shouldn't be. They should be going out looking for it. The defendant is not charged with a simple OUI offense. She was indicated for second-degree murder. So, all right. So basically, there's no reason to limit the medical statements because she's not charged with a DUI, is what they're saying. So, as found by the Supreme Judicial, all right. So this is just boring stuff. All right. So let's skip this one. And thank you guys for staying with me. I know I could pull these up on the screen, but it takes a little longer to do that. So actually, that's the reason I'm not doing it. So I apologize. I'm not sure. Everybody's got to be kind of patient tonight because this wasn't something that I really had time to prepare. Got all these documents. So let's see. All right, 7/3/17. This is docket 317. All right, so 282 is one for the defense. All right, so yeah, let's open 282 because I'm told that's a good one for the defense. And we want to be balanced. So if you are out there and you lean towards the defense and you have something, one of these documents that you're aware of and you want me to look at, just message or say it in chat. I might not see it. Tom will message me. So this one is from the defendant's motion to exclude irrelevant and inadmissible and prejudicial prior bat. Oh yeah, I think that's the one I talked about though. That is the one I talked about. So this is the one that talks about the Aruba trip. During the state grand jury, the Commonwealth also called on Laura Sullivan as a witness to testify about the same incident, but it was not something that she observed. They saw Karen and John at the pool, and Karen was giving John an earful, and because she wanted him to get out of the pool to get ready. I mean, that's just normal relationship shit. It just sounds like a bunch of people here testified that they didn't really like her. So I don't know if that means anything important. It really doesn't, because opinions could be affected by, if she was in a fight with John, it might have made her more of a bitch that weekend, which would affect how other people viewed her. Might not be fair to her. Also, this testimony comes after the accusation of her killing John. So I don't think it's necessarily of too much interest to me. So this one is from the Commonwealth. Prohibit reference to any yeah, I've already read that one. Again, I apologize, guys. Didn't have time to go through these beforehand, so I went through a bunch of them. 317. All right, so let's just open up another random one here. I'll just open them and kind of do quick shots. This is from, well, that's from Alan Jackson, but it's just repeating something. So Karen here, again, wants to exclude evidence based on timely discovery. Karen reads motion for attorney-conducted panel voir dire. Now comes Karen Reed and respectfully moves this honorable court for an attorney-conducted panel voir dire of the jury. All right, so this is about the seating of the jury. And so I'm not sure exactly how this works, and maybe Kevin can come on and explain it better, but you have different types of processes. There's a questionnaire. There is the questioning of the jurors. There's the judge questioning. There is the attorneys questioning. The attorneys have a certain right to remove an X amount as they're seating the jury. The right of refusal, it can be based on anything they want. So, but that's an interesting process, but I don't know anything about it. All right, here's another one from Karen. All right, so the prosecution plans on taking the jury to the crime scene. And it sounds like they even want to tow the vehicle there. I don't know if I misread that earlier, but so you want to be able to see exactly what you're saying the defendant could or couldn't have seen. Now it's going to be, I'm assuming they're taking them during the day, so it is going to be different to duplicate night and a snowstorm. But Karen wants to be part of this. Karen Reed specifically requests that the court order I'm sorry, this is actually not to the crime scene, but this is to the Waterfall Bar and Grill. But I did see another document where they are going to the crime scene. So they're going to take the jury to why would they take the jury to the Waterfall Bar and Grill? I actually don't even know that myself. Like, what would be the point? I mean, I guess to take it to the outside of the bar and then just to show the drive. Okay, so I guess that's, yeah, all right. So they want to show the route from the bar to 34. There you go. Yeah. Does that make sense? And Karen wants to view this process. All right. That's going to be a crazy day in Turtle Country. I don't know how you take the jury out of the court. It's going to be pretty damn hard. They're going to hear the noise that's made by those turtle kooks, especially if they know that that's what's going on that day. They're going to be a block away doing another rolling rally. Defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Oh, this is all right. So this is really interesting too. So we found out last night that the state is adding the evidence about the charges and all the material related to Aidan Kearney's case from November. And so people were asking me last night, Like, what do you think this is? Why would they want to have Aiden's case in there? And didn't really figure it out till today, but I think it's because Aiden has admitted, well, I'm not sure exactly, I don't know the wording, but the state has definitely said that Aiden was leaking federal material to Karen. I'm sorry, that Karen was leaking federal material to Aiden. And so that could be relevant here as, I don't know. I mean, it could be relevant because as if Karen is innocent, why is she leaking this kind of material in a way that might not be exactly accurate? I don't know. There's a lot. I do think it has to do with that, though. I'm not exactly sure. Exactly. I haven't thought that through very clearly. Let me just read through this quickly and see if there's anything in here. Argument. Evidence for Mr. Kearney's alleged harassment or intimidation of Commonwealth witnesses is not relevant. I would say that that's probably true, but I think that we're going to get to here is they want that evidence because of the Fed stuff. Should the court find that the proffered testimony is relevant, it should still be excluded because it has really very limited probative value. All right. Well, interesting stuff that once you get in bed with Aiden, defendant's motion to exclude the blood plasma. So she wants to fight evidence of how much she drank. All right. Let's see. Defendant's motion for sanctions and exclusion of evidence based on. So I think this is going to, yeah. So they want to get rid of the Bodie stuff. That's going to, this motion is going to be granted because they weren't going to get that in a timely way. All right. That's a repeat of that. Let's go up further. So, and I'm gonna hopefully I'll get to this here, what's in the motion, but the Commonwealth has also filed a motion that to prevent, let's see if I can get this, to prevent, I don't know, I can't find the wording here, but I hope it will come, but they filed in their motion something about trying to prevent the defense from running with the third-party culprit theory. So that will be really interesting if we can find that. Let's see. Order to impound, all sidebar. All right, that's boring. See, there's a lot of routine stuff that goes in a trial, and it's important, but it's not interesting to us. It's the boring parts that go into the cake. Commonwealth's motion to disable ability of observers on remote platforms from being heard in courtroom, and Commonwealth's request for notice regarding television cameras. All right, well, let's see this. This might affect all of us, right? Let's see. So they want to use a system that doesn't allow disruptions because they have had in previous hearings using Zoom that people would, manage to get in there and shout out free Karen Reed or free Turtle Boy or something like that. They want to make sure they don't have that. So they want to switch to this thing called a WebEx platform and explore any additional options. Moreover, the Commonwealth moves for advance notice of whether the court intends to permit any television cameras in the courtroom during the trial, and if so, to what extent or limitations. And then it cites the law that says a judge may impose other limitations necessary to protect the right of any party to a fair trial or the safety and well-being of any party, witness, or juror, or to avoid unduly distracting. So I just assumed that because all these hearings have been on TV, that this would be. But I don't know. I guess it's not definite yet. But I think it's pretty likely that I don't know why they would change it at this point. Of course, a trial is different because now you have a jury. You have to keep their identities hidden. You have to keep, I'm not sure to what extent you have to keep the camera off of witnesses. I don't know. I mean, it's a difficult thing. So you have John's nephew and niece will testify. I'm not the niece might be an adult now. I'm not sure, but the nephew is not. I don't think the niece is yet either. So, can cameras film a child testifying? That seems like that would be a problem. Decisions concerning the sequestration of witnesses. All right. So the Commonwealth wants to sequester witnesses and family members. Not really sure exactly what that means as far as how that's applied, but obviously the court would know. Let's see this one here. The Commonwealth moves to allow an in-court identification of the defendant in accordance with the rule. I don't know, that seems boring too. Admit the victim's photograph. Yeah, no shit. Motion to admit photographs of the victim's injuries from the autopsy. I mean, we've already seen that, so I don't know. This is kind of weird. The Commonwealth's motion to preclude reference to and redact the manner of death contained on the victim's death certificate. I don't, no idea. Like, why is it that they can't cite the manner of death on the death certificate? I don't really know. And I don't even, you get into when somebody dies like that, it's not always known exactly what the cause is because there could be a multiplicity of causes. So I don't know. The Commonwealth's motion to admit the 911 call. All right, this could be interesting. The Commonwealth moves to allow into evidence the 911 call made by Jennifer McCabe So we've heard this call before, but we didn't hear it from the police version. We heard it from Karen. Was in the process of calling John when they got to the scene, and then she sighted John on the lawn and threw her phone down and ran out with the phone still calling John. So then this is really weird, right? I mean, just everything in this case, right? Like, what are the chances of the blizzard of the decade there, right? And this strange situation where she backs up into John's car in the driveway. And I know that's so strange that a lot of people have thought that she did it on purpose, and maybe she did. But if she was trying to do it on purpose to cover the broken taillight, wouldn't she have done it a little bit harder? She did it very softly, didn't leave a scratch on John's car. So it may just be a coincidence that she backed into that same taillight. But what a strange coincidence, right? And so then here we go. Whoever heard of anything like this, she's calling John and then sees him, throws the phone down. So while the phone is sitting in the car, it connects to his voicemail. And Jen is within the car and calls 911. So that call gets recorded on John's voicemail. How strange is that, right? Could Karen have been clever enough to have done that for some reason on purpose in that state of mind? I mean, it's just, maybe Maybe there really is an evil genius in the case, so someone could think that shrewdly to try to, but I don't even know what advantage it really was to her to do that. Other than to show she was, you hear her screaming a lot, Carrie, Carrie, Carrie. So she was very upset. So if she did that, if she was clever enough to do that on purpose, then maybe what she was thinking is, I want to show how surprised and how upset I am. So in other words, at that point, if she did it, knew she did it, then she wanted to show that it was an accident. And so she played a role of being the person who just learns that her boyfriend's out on the lawn. An extrajudicial statement made by a party opponent is an exception to the rule against an introduction of hearsay. Yeah, I don't think it's hearsay if you're hearing the call. The defense. All right. So, but keep in mind, so the 911 call was made by Jen. So is it hearsay stuff that Karen says not into the phone, but the phone picks up? I think that's the issue here. Yeah. So it doesn't seem likely that there was that much useful on that call, but I don't think I can't see any reason why it would be thrown out by the judge. All right. That's stupid. Finally getting through these guys. Not too many more. Hopefully we'll get something huge soon. Yeah, this is Commonwealth wants to get Corey records for the potential jurors. That's to make sure they have no criminal past. So the Commonwealth wants to allow a view of the scene where the death of John took place. So they want to include the locations include the front exterior of 34 Fairview, the driveway of 34, the front yard of 34, the public roadway of Fairview Road from 34 to the intersection of Cedar Crest, and the interior and exterior of the Lexus. The Commonwealth intends to have the mass. I knew I saw this somewhere. The Commonwealth intends to have the state police tow this particular vehicle, Karen's SUV, to the public roadway. That same SUV that Sean thinks that Wanless was part of the conspiracy in removing taillights for reasons that never could be explained. All right. That will be interesting. I don't know why they can't just get a similar Lexus and drive it there, but the Commonwealth. All right. This is interesting. This is a little bit interesting. The Commonwealth regarding the use of leading questions. Evidence may be elicited by leading questions when the witness is a child. And then there's some. All right. So there's only 2 kids testifying, and they're not little kids. The motion from the Commonwealth to admit evidence that the defendant was in custody for a period of time after her arrest. The Commonwealth moves to offer evidence that the defendant was in custody for a period of time. As reasons, therefore, the Commonwealth would assert that during the course of the investigation, the defendant was placed under arrest and transported to the Massachusetts State Police Milton Barracks, where she made certain unsolicited statements. We talked about this a little bit before, so let's see if there's more information here. Yeah, so actually, this is the same one we talked about before. Sorry. So the motion regarding opening statements and a notice of any visual aids the defense intends to display to the jury during an opening statement, the Commonwealth moves to instruct the defense counsel to confine their opening statement to the established bounds of Rule 24, whatever the hell that is. The proper function of an opening is to outline in a general way the nature of the case, which counsel expects to be able to prove or support by evidence. He should not be allowed to state facts which are irrelevant or for any reason plainly incompetent. That's An opening statement has a narrow purpose and scope. It is to state what evidence will be presented to make it easier for the jurors to understand what is to follow, and to relate parts of the evidence and testimony to the whole. It is not an occasion for argument. To make statements which will not, or cannot be supported by proof is, if it relates to significant elements of the case, professional misconduct. That's worth repeating. So Alan Jackson is not going to do a lot of the bullshit that he's been doing, and that he's been warned by the judge now. He was warned most recently against distortions and misrepresentations of facts in evidence impounded by the grand jury, by the impounded documents. Obviously talking about the feds. So, to repeat, you cannot make statements which will not or cannot be supported by proof if it relates to significant elements of the case. And if you do that, that's professional misconduct. Now, but I would, obviously, I think a lot of leeway, understandably and rightly, in this country is giving to defense teams a lot of latitude, but not an indefinite latitude. So, for instance, what Alan Jackson did, saying that the state could have used a 2023 version of software in 2022. Now, that won't come up in the case, I don't think, but those kinds of things, they really push the boundary of what's misconduct. They really do. And even like when he said there's a gap in the library video, that really walks up very close to misconduct, because there's no evidence of a gap. There's no evidence of anything removed. Moreover, the Commonwealth moves for an order to require that the defense identify in advance any visual aids, potential exhibits, or potential chalks. All right, big deal. All right, so if they're going to use any displays, they have to present a copy. All right, next document. Yeah, more about visual aids. All right. We're getting near the end, I promise. The Commonwealth seeks to use the following. All right. Interesting. The Commonwealth seeks to use the following: surveillance videos, photographs, video from the accident reconstruction, diagrams, scene and roadway, and diagrams of digital and forensic extraction reports to be projected onto a screen by a computer. So they're going to use video from the accident reconstruction. Are you listening, Sean? Are you listening out there? Are you paying attention? Or are you on your channel right now distorting things like Alan Jackson does, or letting Lauren De Laguna come on there and tell lies? I hate to bring it up, but I mean, I watched this video where she's on a show. I don't know if it's on his channel or with the young jellyfish. It was either, but the three of them were there. And she's saying how I threw Kate Peters under the bus, how I admitted that she lied or gave me false evidence, and that I cut the cord with her. It was just a complete lie. I made clear in my statement that all of the evidence that Kate has given me, or any statements that she has made, has always proved to be credible, with the exception of one piece. And this was something that She didn't lie. It was something she got wrong. This was about she thought that the federal grand jury back had wrapped up and had a no true bill vote back in the fall. And she had reason for believing that because I had other sources that had similar things because we'd all been hearing about testimony that had been subpoenaed testimony that was scheduled with witnesses that was canceled. So there was reason for her to come to that conclusion. But that's the only mistake that she ever made. Now I've never thought that, still in good terms with Kate, and she is a source, but she's not my main source for most of the stuff that I get. But the things she has given me over time have always proved to be credible. And she is also someone that is way more intelligent than Sean or Laguna if they shared the same brain. And she's a very intelligent person, much more intelligent than me. Not that that's a high bar, but not only is she smart, but she actually does have a conscience and cares about the victims and wants to do the right thing here and wants to do the legal thing. I don't follow the nitty gritty of all the wars between Kate and Aiden, and I don't doubt that she has sometimes used some of those tactics. She's a street fighter, but that's it. There was, Lauren, everything that she said was a complete, she very much does what Alan Jackson does, distorts and misrepresents. So that's her way though. But what are you going to do? In that discussion with her, I wanted it to be a civil discussion, and she came in and wanted it to be a debate. And her whole purpose was to go with questions that were probably developed by Aiden and try to score points with them and to use Sean's tactics of continuously interrupting me to see if it would provoke me. So I just calmly took it and hoped that it would be I knew she was under a lot of pressure from them. So I'd try to be very understanding. I didn't think she was making, for the most part, good points. A couple of them were pretty good. But I was like, just, it's all about growth, right? All of it, give someone a chance to get better. But then I see all these crazy things that she's saying, and I realize she's just another nutty turtle rider. So, and other people had warned me of that, but I don't care. I'm like, not that I don't care about the warnings, but I mean, to me, if you've had polite discussion with me and you're willing to do that, then that's fine. But unfortunately, when you get with these turtle riders, there is that whole Aidenism thing. They just don't want to tell you the truth. And they want to use these kind of nasty tactics all the time. It's like their bread and butter. So this was if the court finds that the defendant has made. So let me see. This is part of let me see if I can find this letter. This is part of something more interesting, but it came in a partial. Let me see if I can find this. I've got one here that's from looks like a really good one, but I've only got the last paragraph in it. So I'm trying to find the whole thing and can't quite find it. So I'm almost through these. Freezing up on me. Adobe PDF is doing the spinny thing on me. I don't even know if that's interfering with the show. So let's. Again, for everybody watching, I apologize that this seems a little disorganized, but I got in a batch of 30 or 40 documents. So some of these, you're just going through them as best you can without having had time to prepare them. And so it can seem a little bit, Adobe is really, I'm going to shut this down. Close program. All right. All right, let's try this again. So apparently there were some out-of-court statements that were picked up by police cam, but I have no idea what was in them. Oh, this one's interesting. All right. The Commonwealth moves this court into evidence numerous recorded statements by the defendant to Boston Magazine reporter Gretchen Voss, Dateline News correspondent Dennis Murphy, and ABC News. The Commonwealth would introduce these statements through playing the recorded video statements of the defendant that appeared on national media outlets and depict the defendant sitting down for an interview and making these statements, as well as playing for the jury audio recordings of the defendant that could be authenticated by reporter Gretchen Voss. And I know that those statements are going to, the one that's with Voss, I'm not going to, talk about it, but just say it's going to be extremely compelling. And when you guys hear that, it's going to be mind blowing. It's just going to be one of many things that it becomes really hard to maintain your membership in the Horde when you hear stuff like that. In these recorded statements, the defendant details what transpired prior to the victim's death, the nature of her relationship with the victim, her alcohol consumption, her travel to 34, her actions in the morning and in the aftermath of locating the victim, her statements to first responders, and when she alerted witnesses to damage to her taillight. Notably, the details of the defendant's statements vary. Now, look, this is going to be, and anybody makes statements. This is the thing with, for instance, if you're going to try to compare witness testimony in front of the federal grand jury to the state grand jury and to maybe to their early interviews with the police, there's always going to be discrepancies. So it's not necessarily a problem if Karen has inconsistencies, but it depends on how much they are. So if you're telling someone early on that the last time you saw John was at the waterfall, and then later on you're saying you dropped him off at the house and that's it, and then later on you add in, by the way, I saw him walk up and poke his head into the door. That's a lot of memory to come back, and that doesn't happen. I don't think that happens. So according to the state, the defendant's statements vary, and there are some inconsistencies between the recorded statements as well as inconsistencies with statements the defendant made to law enforcement prior to her arrest, and inconsistencies with a written statement the defendant produced to federal law enforcement. Oh, so that's interesting. Wow. I didn't realize this. So wow, that's a nice little thing. I wouldn't say it's a bombshell, but it's pretty interesting to hear that Karen has made a written statement to federal law enforcement. Now, why didn't they have Karen come in to testify? Right? I mean, shouldn't that be part of their investigation? And you would say, well, you plead the fifth, right? Because you don't have the right, you shouldn't have to testify. But that's why you don't do this while a trial is underway. An extrajudicial statement made by a party opponent is an exception to the rule against the introduction of hearsay. The defendant voluntarily gave these interviews while represented to counsel who were present for the interviews and who should know that under Massachusetts rules of evidence, any statements made would be admissible. People, when you hear this stuff, some of this stuff, it really shatters. Not only the taillight was shattered, but David Yannetti's reputation as a lawyer has been shattered. I mean, to me, it's just common sense. It's common practice by any attorney to not let their clients talk to the media. But when do you see a murder defendant, somebody on trial for murder? When do you see their lawyers letting them talk to the media? Does that ever happen? Did that happen in the OJ case? Did that happen in the Murdaugh case? I mean, it doesn't happen. And these guys are running all around having her make statements to multiple different media sources. And, and those statements were inconsistent with other statements that she had made to the police earlier. And Yannetti had to know that. He had to know that. So why was he allowing her to talk? And like I said, when you hear this audio of Gretchen Voss, you're going to be like, wow, what have these people been selling me? What has Sean McDonough been selling me? I don't want to buy it anymore. You're going to say that. Trust me, you are going to say that. All right, this is 310 on the docket. Ooh, okay. All right. So the Commonwealth wants to introduce evidence of motive and the nature of relationship. Let's see what this says. It is a well-settled law of Massachusetts that they may introduce evidence of the defendant's criminal or wrongful behavior to show a tendency of bad character or propensity to commit the crime that's charged. Wow, I want to see what's in this. However, evidence of prior bad acts, though not admissible to show bad character or criminal act or criminal propensity, may be admissible to prove opportunity, intent, preparation, plan, knowledge, pattern of operation, or common scheme or course of conduct, as long as the probative value of the evidence is not outweighed by the risk of unfair prejudice. So I wonder what they're going to introduce here. Now, there's a lot of stuff that I'm aware of that I don't talk about from her background, and I still don't want to unless the state introduces it. So I'm not going to. But there's a lot of problems there, and I didn't know if this stuff would be allowed. I still don't know. Determination to admit such evidence based on timeliness, place, character, or probative value is one for the trial judge to make. Okay. So, for example, let's say you are accused of robbing a bank, and they're able to find evidence that shows 10 years ago you planned to rob a bank and took some steps towards it. Maybe you took some action. Maybe you and your friends went into the bank with masks, but then at the last second you decided not to do anything. So there wasn't an act. I don't know. I mean, that's a hypothetical, but that's relevant. Whereas it wouldn't be relevant if they find that in the past you were drinking underage, or in the past you got in a fight. That's not relevant to the case to robbing a bank. So if there's anything in Karen's past that would be in some way showing a pattern of committing a malicious crime, especially one that might involve jealousy of a boyfriend that was breaking up with you, those things could be relevant. The Commonwealth seeks to introduce testimony through percipient witnesses. Percipient? Damn, what the hell does that mean? Who observed the defendant. Tom, what does percipient mean? Who observed the defendant and victim's volatile and hostile relationship if it existed at the time of the victim's death. All right, so I guess this is just going to be about Aruba. So it's not going to be about like past incidents or anything like that, deeper into the past, like past boyfriends. The incident in Aruba seems to also be a turning point in the relationship, as the defendant told Brian Higgins, in a series of text messages shortly thereafter that a relationship with the victim was. So these were in text messages. So we know that we've seen that there's numerous messages entered in discovery from ATF agent Brian Higgins, who was in the house, 34 Fairview, and who left after John was apparently struck by a vehicle, and who had been having an affair with Karen for a couple of weeks. And so one of these texts says that the victim was a very fucked up situation, and details that she observed the victim all over a friend's sister in the lobby of our hotel, and accused the victim of having hooked up with another girl. These are her text messages, so it's not going to be hearsay. These are her text messages. Another one that she screams at the victim for apparently. Oh, so I'm sorry. So in the voicemails left on the victim's phone, So when she was angry, after she hit John and she left a bunch of angry messages on his phone, one of them she says, for fucking another girl. So Joan went on Sean's channel and tried to make it seem like it was Camelot. No evidence for that. That's just something that Karen is spinning through Joan. Following the public incident in Aruba, the evidence will also demonstrate a continuing animosity between the defendant and the victim in the weeks and days prior to the victim's death. Now, that doesn't mean that Karen wanted to break up with him. I mean, I think Karen probably wanted to rein him in or something like that. So, I mean, but there was a lot of friction there. In the days prior to the murder, the victim and the niece will testify they heard the victim communicate his intentions to end the relationship. Also, the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with him. So that's the last thing she remembered that's the last thing that she remembered from that night. Let's see if there's anything more. All right, so that's it. I don't think you'll hear anything about like her past relationships. It's just going to be stuff from a month before in the fight. The Commonwealth, next one here, motion for attorney conducted all right, so this is about looking at the jurors, their seating of the jury. So let's go to the next one. The Bowden defense. What is the Bowden defense? Now comes the Commonwealth and respectfully requests that if the defendant intends to offer a Bowden defense, what is a Bowden defense? That the court conduct a voir dire hearing to determine whether the probative value of the Bowden evidence is not substantially outweighed by the risk of unfair prejudice to the Commonwealth. All right. This is about the third-party culprit stuff. All right. Interesting. So, in another case, the judge properly exercised discretion to exclude third-party culprit evidence as part of a Bowden defense where defense counsel's proffer did not demonstrate that the probative weight of the Bowden evidence exceeded the risk of unfair prejudice. Oh, we're going to need Mahoney to explain this one to us a little bit, or definitely. But so the judge properly exercised in this other case discretion to exclude third-party culprit evidence as part of a Bowden defense, where defense counsel's proffer did not demonstrate that the probative weight of the Bowden evidence exceeded. All right, so you have to be able to show that your evidence that points to a third-party culprit theory has to outweigh the risk of creating any unfair prejudice. That's tricky. I would definitely need a lawyer to explain what the rules are for that kind of thing and how the judge could decide that, because my first instinct, it seems like that generally that's a jury should decide that. But let's say defendants have the right to base their defense on the failure of police adequately to invest. Okay, so all right. So the defendants have the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt. All right. So you can't just throw out there your third-party culprit theory. You have to show that the police didn't try to find evidence for that. You have to show that they didn't adequately investigate the murder. So I think that's what that says there. I mean, that's still, I'm not sure. You have to, like, if all of a sudden, all right. So yeah, that makes sense, actually, the way this, all right. So the police reports detailing the incriminating, all right, let's get to the actual. If known to law enforcement, a failure to investigating leads concerning another suspect. Sorry. So if the defense was finding evidence of a third party culprit thing, they're required to make sure the investigators get this so they can investigate it. It's, kind of a good faith thing. I know you on the Free Care and Read side said, well, that doesn't make sense because these cops were corrupt and Trooper Proctor, whatever. But the evidence seems to show that they did investigate any potential leads that were given to them that might show that. And nobody has shown any evidence that Trooper Proctor or anybody else in any way ignored key evidence or certainly not planted any evidence. So, and you have to show that. So if you're going to run this third-party culprit defense, you're going to have to show that the state police didn't chase down any of that information. And I don't think they're going to be able to do that. Information regarding a third-party culprit whose existence was known to police but whose involvement was never investigated may be sufficient to raise a Bowden defense, even though the evidence may not otherwise be admissible to a third-party culprit defense. While often confused with each other, third-party culprit and Bowden defenses are logically and legally different. Evidence admitted pursuant to a Bowden defense is not hearsay because it is not offered to show the truth of the matter asserted. So if they heard, so what they're saying is if somebody heard that John was killed in the house and the police didn't look into that, it's not hearsay. The police would have to look into it. If the defendant intends to offer evidence that the police knew of an alternative suspect and failed to take reasonable steps to investigate, the information may be admitted simply to show that information was provided to police and not adequately investigated. However, this does not mean the defense counsel may always be able to admit third-party culprit evidence as part of the Bowden defense, even when it would otherwise not be admissible under a third-party culprit defense. In contrast to the third-party culprit defense, where evidence may be admitted regardless of whether the police knew of the suspect, third-party culprit information is admissible under a Bowden defense only if the police had learned of it during the investigation and failed. All right. I'm not a lawyer here, but let me see here if this is what it is. You have a third-party defense, which tries to argue that somebody else did it, or that's third-party culprit defense. Or you have the Bowden defense, which says that there were indications that someone else might have done it and the police refused to adequately investigate them. And they're two separate defenses. And so the thing is, if you're going to go with the Bowden defense, then you're going to talk about Trooper Proctor and things he did or didn't do and things that Buchanan didn't do. But if you're not going with a Bowden defense, I think what they're saying here is you can still propose a third-party culprit defense, but you cannot talk about theories of corruption by the police. So it's an either or. If you're going to go with the Bowden defense, then you can talk about that corruption. But you better have grounds to show. You can't just throw it out there. You better have grounds to show that the police didn't properly investigate. And I think the reason they have to distinguish these two here is because if you're going to throw a third-party culprit out there by itself, not part of a Bowden, then it has to be based on some kind of substantial material that could have conceivably been true. It has to be based on some kind of evidence. You can't just throw it out there if there's no evidence. Further, a defendant does not have an unfettered right to elicit evidence regarding the adequacy of the police investigation. The admissibility of such evidence hinges first and foremost on its relevance. Relevant evidence means evidence having any tendency to make a consequential fact more or less probable. So, I mean, you can't fault the police for not investigating something that it wasn't really all that important for them to investigate. The Bowden, so going on, the Bowden defense is a two-edged sword for the defendant because it opens up the door for the Commonwealth to offer evidence explaining why the police did not allow the line of investigation suggested by the defense and detail what investigative steps were taken. Yeah, so I guess you have to tell the court ahead of time if you're doing the Bowden defense, because there are things that might normally not be allowed by a judge to be put forward by the prosecution, and here it would open it up. The more wide-ranging the defendant's attack on the police investigation, the broader the Commonwealth's response may be. So yeah, if you start really making a broad attack on the investigation, then in order to reply to that, they might be able to bring in evidence which normally would unfairly smear the defendant. So that's the risk there. So, for instance, the police detective could testify. All right. So this is all right. Yes, law is great. Law is fascinating, right? So, for example, just to support what I'm just saying there, the police could have a confidential informant that talked about this defendant's motive, but that would be hearsay and it would not be admissible in the trial against the defendant. However, if they're going to go with a Bowden defense, then the officer would have the right to say, well, this is the reason I didn't investigate option B was because I had good evidence for option A, and that included stuff from this confidential informant. So then it would be allowed. It normally wouldn't be allowed, though, because it would be hearsay. So that's something that could actually hurt the defense. So I think the defense has to tell the court ahead of time whether they're going to go with the Bowden evidence. This is fascinating stuff. It really is. Would be great to be a lawyer. The defendant intends to offer Bowden evidence. If the defendant intends to offer Bowden evidence, this court should conduct a voir dire hearing. My Latin's not great. It's non-existent. Sometimes my English isn't great either. This court should conduct a voir dire hearing to determine whether the evidence proffered by the defendant has the probative weight to exceed the risk of unfair prejudice to the Commonwealth and would not confuse the jury by diverting their attention to collateral matters. Baseless claims on relying on the word on the street carries no indicia of reliability by itself. And when defense counsel fails to bolster unreliable statements by showing, for example, that the information came from the percipient witness, hopefully, Tom, you got back to me what that meant, a Bowden defense should be excluded. Likewise, if the defendant intends to claim that police lost or destroyed evidence, she bears the initial burden to establish a reasonable possibility based on concrete evidence that rather than a fertile imagination. So just to wrap up this one, if the court finds that the defendant has made a sufficient showing and allows the defendant to pursue a Bowden defense, the Commonwealth intends to introduce a substantial amount of evidence that police adequately investigated the crimes and continue to investigate to debunk a variety of defendants' speculative and unreliable claims. For the foregoing reasons, the Commonwealth respectfully requests notice of any Bowden defense and voir dire to determine whether the defendant's proffer is sufficient before evidence and argument is made to the jury. So they want to know if that's going to be part of their argument, part of the defense's argument. From docket 221, the Commonwealth's motion, and that's more on the Bowden defense, so let's skip that one. Commonwealth wants advance notice if the defendant intends to cross-examine any witnesses about alleged bias and requests for pre-trial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. All right, so this is we're hearing that there's been some troubling text messages by the police Would that be enough to show bias? So this is something that the Commonwealth wants advance notice of. All right. This never-ending list of documents. Now you see all the stuff that came that I had to go through. All right. So the Commonwealth motions to prohibit reference to any pending internal affairs investigations or unfounded allegations of misconduct. Yes, you can't. So if the internal affairs hasn't completed an investigation and doesn't have a report, I don't think they can use it. I don't think the defense can use it. So the Commonwealth wants to prohibit reference to any of the federal investigations or the FBI. And see if I may have gone through this one earlier. As I said before, revealing the mere existence of a federal grand jury, particularly one that has no target, no resulting criminal charges, nor any factual evidence that would considerably undermine the Commonwealth's case is irrelevant, has no tendency to prove any material issue. So look, I mean, the state is saying there's nothing in the federal stash that was handed over, the material, that in any way is relevant to the defense in any significant way. So now you may disagree with that. You haven't read it. I haven't read it, but the judge has. So she'll be able to make a fair decision on that. And this is a judge, by the way, that all the lawyers that I've talked to say has a reputation for being very pro-defense. So if you're a defense attorney, you want Judge Canone. She has that reputation. Commonwealth's motion to exclude mention of Aiden Kearney, aka Turtle Boy, and his pending criminal charges. It's funny where they added that evidence, but yet they don't want to mention him. Commonwealth moves to exclude any reference to Turtle Boy, his blog postings, his protests in support of the defendant, and his pending criminal charges. As grounds, Mr. Kearney is an extremely vocal observer of this case. He is not a witness to the facts and circumstances that led to John O'Keefe's death and is only peripherally related due to his criminal conduct of harassing, intimidating witnesses. Reference to Mr. Kearney, his blog postings, or the pending criminal charges he faces have no rational tendency to prove any material issue. The Commonwealth is also to instruct its witnesses not to discuss the relentless harassment they have endured. And they have. All right. Another one. Commonwealth seeks to prohibit defense experts from testifying regarding scientific studies and anecdotal experiences and request for voir dire of any proposed defense expert. Let's see what this is short, so we'll read it. The Commonwealth moves to prohibit any defense expert from testifying regarding current scientific literature and research as it's inadmissible hearsay. I wonder what scientific literature they have in mind. The defendant has yet to provide the Commonwealth notice of any expert witnesses or their anticipated testimony. However, the Commonwealth moves in this court to prohibit any testimony regarding scientific studies or anecdotal experiences. It must have something in mind. While literature may properly constitute the basis of an opinion, it is not admissible during direct examination. On direct examination, a qualified expert witness may... Oh, this has to be about the dog bites. Because I don't know. On direct examination, a qualified expert witness may testify to facts personally observed, facts and evidence, with the court's approval, facts that a party will put into evidence. Further, an expert witness is prohibited from testifying to the ultimate determination of guilt. I'm not sure, so I really don't know. What I'm thinking, maybe that's about the dog bites, but maybe not. Who knows? Commonwealth motion against any witness to be asked for opinion of character of the defendant or of any of the witnesses. That's probably standard stuff. To exclude character evidence of the defendant. Yeah, that's pretty similar. And the bad character one again. Motion to admit the victim's out-of-court statements relating to his state of mind. The Commonwealth wants to allow into evidence John O'Keefe's statements to his niece, nephew, and family members and friends regarding the defendant's intention to end his relationship with the defendant and statements about the tumultuous nature of their relationship, which are relevant to the victim's state of mind. The Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. So we're going to see testimony from some of the family members and some of John's friends that say that he had decided to terminate the relationship, which is completely opposite of what Crazy Joan was saying. But the Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant. So there are text messages from John to Karen saying it's over. Now, in fairness, when you're in a fight, you can go through a lot of back and forth to that, where 1 minute it's over and then a couple hours later you're in love again, right? So, I mean, there was an episode of Seinfeld where Elaine's boyfriend was kind of this goofy kind of big guy who's gone on to have a great career. But they don't have anything in common and he's not too bright. So they've been fighting and breaking up all along their vacation to Europe. And then they're on the plane, they're in the cab and they're on the plane and they keep breaking up and then getting back together all on the same trip, so that does happen. Actually have my first, let's see, I got a message and let's see if it's anything related to this. It's from Judy. All right. The Commonwealth contends the victim's state of mind is relevant to the defendant's motive to kill. The defendant and victim's relationship had deteriorated. And both of them had made statements to that nature. Whereas the defendant has repeatedly accused others of committing murder, the jury should be permitted to consider all evidence that demonstrates the relationship and hostility between the defendant and the victim at the time of the murder. Interesting. So that would be a factor in deciding that the fact that she's accusing other people. So, the defendants described the murder as an accidental shooting. What? Oh, that's in another case. I'm sorry that they referenced. Whew. Oh my God, that's the end of it. All right, finally, and let me just check down to see. There was one snapshot of something that seemed interesting, and I couldn't get the whole thing, so never was able to turn up. This was something that I'm missing the rest of this document. This is just the last paragraph. If the court finds the defendant has made a sufficient showing and allows the defendant to pursue a Bowden defense, Oh, no. Okay. So we did that. That was the Bowden one. All right. All right. So that's it. Managed to get through all these documents. I know that was tedious. It was as tedious for me. It was way more tedious for me than it was for you, although I'm sure it was tedious for you guys too. So I apologize. But that was just the nature of the beast. If we're going to deal with that stash that came through today, I had to just do it that way. That was the only way. I didn't have time to put it together. So let's look to the, been on for a long time and getting tired, but let's look to the questions and comments here, and we'll highlight some good stuff. Hillbilly Nitro, good to see you. He's done some great work showing us how the video from the ring system at John's house of Karen leaving at 5 a.m. clearly shows there were substantial pieces missing from that taillight. That's game over. There was definitely substantial pieces missing by 5 a.m. So you have to, your conspiracy is now down to somebody broke into that garage between, say, 1 and 5 a.m. and tampered with that taillight and then took those pieces and planted them at the scene. That's the only way this can be a conspiracy here. There's no evidence the garage was broken into. The ring system didn't pick up anybody showing up to break into the garage. So we'll see. Lori said she enjoyed it. Thank you. I mean, appreciate it, because it was tough getting through all that, and would be a lot easier to go through it and put it together. Tediosity. I don't know if that's a real word, but I like it. Sounds like a good word. So guys, please do us a favor. If you're out there watching, even if you hate my guts, hook a brother up and just click subscribe. It won't cost you any money. Tom's always reminded me to say that. So just coming out here and seeing him, I said, all right. So glancing through, it looks like everybody's having polite discussion in chat, and that's why I didn't feel too bad about taking my time going through those documents, because I knew for a lot of people, it's just they're kind of having their own conversation in chat, and so that's fine too. And we're happy to provide that format, and my voice is there to put you to sleep. Coffee Christian, let's do a comment from Coffee. Interesting that the defense didn't file a motion to exclude the taillight evidence due to the wantless chain of custody stuff we all got put through. Yeah, I mean, all the shit that has been said by that guy, that just none of it is coming out to be relevant. It's just unbelievable. I mean, even Turtle Boy said nothing he ever says has come true or has predictive value. Turtle Boy was taunting him in chat a few weeks saying that, like, dude, everything you say is wrong. Nothing you predict ever comes true. Your literally batting average is 0, dude. I mean, even for like an 8-year-old kid in Little League, 0 is not a good average. I want to say thank you to James, and he actually, while I was blabbing, donated $10. I appreciate it. And he says, Levy seems scared to explain his own actions. The Fed involved enemy appears to be to Smythe and Mirrors, maybe Smoke and Mirrors. So just looking through the comments again. Yes, dog bites always leave puncture marks. I mean, it really, on close examination, hasn't looked like a dog attack to me for a long time. But the fact that there was no canine material found on John's clothing pretty much ends that. And I don't think you're seeing anybody. I don't think you're going to see the defense raise it. I don't know. You never know, because sometimes you raise something thinking it might convince a few jurors, I guess, right? So I don't know. Arthur Pirant says we need to get all these guys in the studio with a moderator. Well, I'm welcome. I'm game, but what we're seeing, and I don't think there's any question of this, as we look at this over the last week or so, is that the other side is running out of arguments. I mean, you could see it. And one of the indications of that is because mostly all they have to do is attack me. And so I'm great. I'm fine. You want me to absorb that. It's not like this is a fight. This is actually just YouTube. But you can see it. You could see the corner was turned when they no longer were able to craft arguments against me. All they could do was try to come up with crap, smear things, weird things, like Young Jelly making things up, like saying that he had a video with a thumbnail that my mom saw that says Kevin was trying to sniff True Crime and Wine. I mean, I've never met her. She lives in New York. I mean, Young Jelly's an adult, isn't he? He's an aging adult. He's middle-aged. But that's all he has left. That's all he has left, really? I mean, if you had arguments, you'd be making arguments. If you don't have arguments, you resort to fifth grade name calling. That isn't even interesting or clever or funny. It's stupid. So, I mean, hey, everybody loves a good clever jab. If someone wants to say something clever, that'll be fine. But that's not even clever. Come on, Jelly. Not only do you not have a spine, Jelly, you don't have a creative mind where you can come up with interesting jibes. Jules, good to see you. Haven't seen you in a long time. Also, as of right now, I don't believe there has been any plea offered to Karen, and they won't be. Yeah, I have not heard of any plea discussions at all. So who knows? I mean, but I do think that if there are plea discussions, if there have been, or if there will be, they will be very well. That kind of stuff will be very, very well contained. So I don't think we'll hear about it. Good Egg says, I don't think they'll bring it up. She's probably talking about the canine, and I agree. Ed Vincent says, I still think there's going to be a plea. Boy, it's running, you can have a plea right up until the jury decides, actually. So you could work out, in theory, work out a plea degree even while the jury is deliberating. Although, obviously, that's really last second, But when is the true last second here? I think it's common in court for the final deal is worked out because they're all going to be playing a game of brinksmanship to say, well, I'm ready to go to trial. And the other side says, I'm ready to go to trial, right? Because if you don't make the other side think you're ready to go to trial, then they're not going to give you a deal. They're not going to give you a good deal, So everybody plays that game right to the last second. So I don't think I don't think it would take long to come up with a plea deal. And in fact, let's just say you wait until the 16th, the day the trial is officially beginning. So 6 days from now. And the defense team decides, let's see what the state will offer us for a plea deal. They still have plenty of time because the jury selection process will take time. Stephanie says, great job tonight, Kevin. Thank you. I appreciate it, Stephanie. Hillbilly says the defense team is the ministry of smoke and mirrors. Yeah, but isn't that what this is what I'm really, another thing that disturbs me about this case, isn't that what defense teams are supposed to do? Do we not understand the basic process of a trial? When we saw this evidence coming across all through on day one, this entire theory was intact. April 18th, Turtle Boy's first blog on this. Even if I knew nothing about Turtle Boy at that point. I'd never heard him or read his articles. But couldn't you tell that this is not like some investigative series that's taken months to develop by a staff of the New York Times? This is something by one blogger in Holden. To come out with something that complete, there was only one way, and that's if it was given to him intact directly by the defense. That's the only way. And everybody should have understood that common sense-wise. Now, that didn't mean that theory wasn't valid or true, but you should have understood and had a little bit of skepticism. Okay, I'm given this by somebody, this theory intact by a defense team, and that's their job, is to come up. You have to have a little skepticism about that, So even if you think maybe there's something weird there, you stand back there and say, okay, let's see the rest of the evidence. And you only had so much. Now, none of us really seem to have access to documents. I couldn't get them I get them now, but I couldn't get them until really late August, early September. So you were going by just what Turtle Boy was saying for weeks and months. And then we got to the hearings and we saw that the state disputed most of these things. For instance, that they disputed the 227 search for how long to die in the cold. So now you're like, okay, we have two different sides. And how can we decide? Now, if you're just going to go without asking any questions and say, well, I believe Turtle Boy, then yeah, that is a mindless mob. Okay, if you don't have questions about that stuff, that's mindless. That's mindless. You don't want to ask questions. you like the guy, or you like the theory for some reason, or you like the way Karen looks, all that shit is mindless. You don't believe the police are honest, or you believe in police corruption, but you don't ask any questions. Do you believe every cop is corrupt? Do you believe every case involves a conspiracy? No, of course not. So you ask these questions and try to find this evidence. And you have to understand that you're only hearing one side. This is just common sense. 65 CJ5 talks about the blunt force trauma that was listed. Trauma to the kidney. No, trauma to the pancreas and maybe the kidney. Ed says the free Karen Reed crowd has been silent. Yeah, they're done. I mean, they don't know they're done, but they're done. They're running out of interesting things to say. Heather says that neither the medics nor the ER docs ever said they thought it was dog bites. Nope, and they didn't. Lisa says she disagrees. She doesn't think the other side is out of arguments at all. Okay. They do seem largely out of arguments, so don't they, Lisa? I mean, most and everything that they put out, if I see it, gets quickly debunked. I mean, it's at this point, there's nothing left. What can they make? So the grifter tried to say on his show, well, I never believed in the taillight anyways. Well, but if you don't believe the taillight evidence was important, if you don't have the planting of taillight evidence by the corrupt police here, then there's no conspiracy, and Karen is guilty. So even though we may not want to hear about the taillight anymore, it is crucial. And when you come out and you say, well, I never thought it was that important. Well, unless you're just an idiot, you completely run out of arguments. And you have no choice but to say, well, I don't believe in it, even though it's like someone shoots somebody and then they find the gun and they match the bullet and you say, well, the gun doesn't matter to me. That's just crazy. Arthur Prince says, if Billy Martin and George Steinbrenner, it's not John Arthur, George Steinbrenner made up all you guys, you can make up and get into a studio. Well, here's the thing. Outside of this case, I really like Sean and enjoyed my conversations with him. And I don't actually have anything against Aiden personally. But it's hard because it's not just they're on different sides of a debate. They're doing things that are wrong. They're doing things that are cruel. They're accusing over and over again innocent people of being part of a conspiracy, calling them murderers when there's no evidence. And at this point, they're only doing it not because they have strong arguments. I don't even know if they have beliefs anymore, but just because that's the hill they're going to die on, as Sean likes to put it. Dude, you really want that to be you have a 28-year career in federal law enforcement, and you want that to be your last thing. You remembered you accused innocent people of being murderers, even though there was no evidence. You accused Paul O'Keefe, the brother of the victim, of being part of the conspiracy. You accused Ken Dougal, his best friend, of being a part of the conspiracy. No, that's not acceptable. Lisa says, I name call too. That's disappointing. It's a real distraction. I'm sorry. I do it a little bit. But I don't do it to people that are respectful and that seem like decent people. I've never said anything bad about Brian of LTL. I don't watch his show, but I'm told by good sources he's a good guy. I don't see any clips of him out there disparaging me. I don't like the way that he covers this case in a one-sided way. I don't understand that. I don't know why anybody would not seek the truth. And to me, there's an element of grifting if all you want to do is just jump on a bandwagon. I don't really understand why people haven't seen enough with Aiden now to say this guy's not a good guy, and I don't want to attach my bandwagon to him. But they want to do that. I don't really understand that. So, but other than that, you never hear me say anything about Brian. But I talk about the grifter because he is a grifter, and a coward. He's a guy that sees the mob and likes to jump in with the bullies. And if he sees he was the kid at recess that if he saw a little kid in the corner, he'd go hang with the bullies and start throwing rocks. He's demonstrated that. That's who he is. All right. So if that feels like an insult or name calling, I'll live with it. And the same thing with Young Jelly. I mean, he can't. I never watched his show. He did it until I heard he was doing a show where he was going to change his thing and try to do both sides. And he did a very respectable job. And he had been silent for a few weeks. Obviously, some people had gotten to him from the other side and talked to him. And so it was enough to make him reconsider whether he'd been being fair. So he just, in a very nice show, he said, I'm going to be fair and I'm going to try to look at questions going forward from both sides. And he apologized for saying things about me. And he said, I'm sorry. You know, the only problem I actually have with Kevin is that he says we're all a mindless mob. Ironically, when he said that, that mindless mob was attacking him. And moments after saying it, he looked down. He's like, wow, I can't believe it. He was like, you people are crazy, is what he said. You can go back and look at it. And because that was the moment when he realized there is a mindless mob. So they were attacking him just for asking questions. But he did it the right way in that one show. But unfortunately, it was only one show because then a couple of days later, from jail, Turtle Boy let the word go out. No more wavering. That's what he said. That's a quote. He mentioned Young Jerks specifically. And then he said, and anybody else. So basically what he was saying is that anybody else who has been covering this from the Free Karen Reed side, no more wavering, or I'm going to get my mob after you. He put the scare of God into Mike Crawford, and Mike Crawford never asked another question again. He went completely back to grifting, terrified of the turtle mob and taking orders from Aiden. So yeah, he has no spine, literally. He at some point it was extracted from his body and he left it on the desk and couldn't figure out how to put it back in. Now, if you're mad at me for saying that, okay, I got to have a little bit of fun considering everything that comes my way. So, Heather is saying that's what I don't like. You can't debate them. They just attack you personally, not about the facts. Yeah, I mean, so like when you saw I had Lauren on, I never disrespected her. I let her interrupt me repeatedly. I let her mischaracterize things that I said repeatedly. It was a bogus tactic, but I wanted to be gentle and fair and I tried to do that with Sean too, but I kept getting constant interruptions. But yeah, I really think it's important to have civilized debate, fair debate from both sides. But there are some lines that have been crossed here. So repeatedly calling someone like Jen McCabe a murderer when there's literally not a single piece of evidence against her. Now, if you want to say you think maybe 227 was true and so you're suspicious, okay. But understand that you're going against the evidence and you're destroying somebody and you're destroying their lives and you're making life hell for their kids. That's evil. That's cruel. People that do that are not good people. And so I'm not going to be civilized to people that do that. I'll be civilized as long as now. So if somebody wants to ask legitimate questions about the investigation on this case, then that's great. I'll have that discussion friendly and happily all day. But if you want to just sit there and point a finger at people when you don't have any evidence, then what you're doing is wrong and it deserves to be called out. And I'm going to call it out. I'm not going to back down from that because I'm going to stand up against these bullies because that's all they are. Joey, 100% dog bites. See, this is the thing. There's no evidence you could ever show somebody like that. There's no evidence. He believes it. He believed it when it was first shown to him and it was told by Turtle Boy, these are dog bites. He got it in his head and there is no evidence you could ever show otherwise. Now, if you look closely at them, you can see they're shallow. They're too shallow to be caused by a German Shepherd. They, at most, might be caught by a cat playing with you. All right. Or maybe a dog playing with you, but not from a dog attack. Not even close to that. You see the horizontal, the linear lines, the parallel lines, and you say, oh, that must be what? Dog nails or dog teeth? I don't know. But you don't see any deep puncture wounds. If you look at the damage from serious dog attacks, it doesn't look like that. But if you wanted to still believe that Up until the canine evidence came back, that was okay. But the canine evidence is back, and none was found on the clothing, and that ends that discussion. And you don't hear the defense arguing it anymore. The grifter is the glare. And because the grifter is a guy from Tennessee who could care less about this case. He jumped on the Turtle Boy bandwagon, and when Karen, whatever happens as a result of this case, he won't care. He'll just go on to some other grift. He's not interested in the truth, and that's just his name. That's just who he is. He's going to make money off this while he can. Pure grifting. Arthur Parent, even on CTV, that's court TV, right? They say they've never seen support like this for a person that is on troll or murdering a police officer. I mean, this is the problem, is that going forward, if this is allowed to continue the way it is, and I'm not trying to interfere with people's First Amendment rights, absolutely not. But where is the limit? There has to be some limits to you're allowing a defense team to use a blogger and to use paid PR people to stir up the public, because this is, and maybe sometimes the only solution is just for the public to be more aware. But it's really important that people understand that we're going to see this going forward because of social media. It's really easy to stir up conspiracy theories, and the people that start to form around those conspiracy theories, just like the Alex Jones stuff, talking about Sandy Hook being a false flag operation to try to like anti-gun control people. I mean, those kids, what their parents went through, their families went through, was horrific. But it's not difficult for him to stir up a conspiracy with thousands or millions of people that want to believe in that stuff. Jules says the motion to dismiss only mentions the original grand jury when they indicted Reed, and they just tried to argue that the grand jury was told everything. Yeah. Yeah, the taillight is definitely not going to, I don't really see it being an issue at a trial. It's now shown, it's going to be shown that it was in pieces, including in Karen's own words. So Lisa said, Lisa, you seem like a nice person, so I want to put this up here because I've made this distinguish on every show. You call Free Karen people a mindless mob, and honestly, that's not true. It's definitely not true that everybody that believes in Karen's innocence is part of a mindless mob. And it's definitely not true that people that have questions about this case. No, of course not. But there is a mindless mob. So there is a mindless mob, and not everybody that believes in Karen Reed's innocence is part of that. So I always want to make that distinction. But what is the mob? A mindless mob are people that are completely impervious to evidence, because for whatever reason, they just deeply, deeply, deeply need to believe there's a conspiracy here for some reason. And they don't question anything. And no matter how often Aiden lies, or no matter how often Sean reports something that turns out to be not true, it doesn't matter to them. They just completely dismiss it. That is mindless by definition. So if you think there are parts of this case that trouble you, sure, me too. I still don't know what the accident reconstruction is. So, and until we see that, there really is, it really wouldn't be fair. There's definitely reasonable doubt until we see what the accident reconstruction is, and it better convince us. And we haven't seen it yet, and we won't see it till trial. We saw a reference to it today in one of the documents that I read about the accident reconstruction. So it's definitely there. We just don't know what it is. And so it's important. But I don't believe that just if you're a good person and you're out there and you're trying to follow this case and you're trying to ask questions on both sides, then you're welcome here. We love having you here. You're not only welcome, we want you here, because we don't want ever to be an echo chamber. We want people that are raising different points of view. Otherwise, you do become like MSNBC. You become an echo chamber, and everybody has that groupthink, and it's crazy. We don't want that. But there is a mindless mob, and if you want to, I'll give you just another example. As an experiment, late in the summer, I had someone. I was not I was banned from the justice groups, and I had someone go over and post in the Aiden Justice for Karen Reed group. I said, why don't you post this? Say that I 100% believe in Karen's innocence. However, I have some questions about this conspiracy theory, and see what happens to you. And she posted in there, and they pounced on her. They pounced on her. So no, that's a mindless mob. There's no debate is allowed, no questioning, or as Turtle would say, no wavering. Yeah, Turtle doesn't. He wants you to be a mindless mob. He wants to be a mindless mob that, as he said in a video back in May, just do what I say. Trust me and do what I say. That's what he said. Joe, we don't know. She said Karen's SUV did not make contact with John. We don't know. All right. We have no idea. We have no idea. Arthur says yes, and zombies, that's not right. All right. So, I mean, maybe I shouldn't say it, but to me, it bothers me when people can't weigh evidence and people don't at least try to weigh evidence and ask. See, when Turtle Boy first was declaring war on me back this summer, it was because he accused me of both sidesism. So, and the whole mob was coming after me because, at that time, because I was asking questions, I had stayed quiet in social media and just asking questions on the channel and other cases, because there was other cases and other things I was working on. But somebody started a post in one of the Facebook groups that was literally directed at me, and it said, Kevin from Yellow Cottage Tales, is something wrong? Listen, the problem they had was just that I asked questions. And as it turned out, most of the questions that I've asked have led me to the truth. And you're seeing that. They're seeing it, and they're frustrated by it, but you're going to see it soon. And not just me, plenty of other people out there. And other people that have done a fantastic job investigating this case. Some of them that I can't mention, and they are sources, but they don't want to be mentioned. But Kate is also someone who I can openly talk about. She's did a fantastic job getting to the bottom of this case. Joey says the feds don't pick sides. What is that? Oh my God. Dude, are you the most naive guy in the state? The feds don't pick sides, only the truth. The feds, did they pick sides in the Russian gate when they were trying to frame Trump for being a Russian spy? And I don't mean I'm not a MAGA guy. And when that evidence first came out, I was like, yeah, we need to have a special counsel here. But pretty quickly it emerged that, and then eventually fully emerged, and I followed that case and that evidence very closely. So it emerged from documents, from declassified documents, and from the Inspector General Horowitz's report, and then later on the begins with a D, I forget his name, his report made very clear. We know exactly how that thing was a conspiracy between the FBI, other agents in the deep state kind of government apparatus, such as the head of the CIA, Brennan, and literally Democratic operatives that created that whole thing. So yeah, this idea that the feds don't pick sides. Oh my Lord, what feds are you talking about, dude? Coffee says it's fine if you don't disagree. Yeah, I mean, we were talking about people that just mindlessly go along following Turtle Boy and don't care how often he lies to them, don't care how often he gets caught with it. They don't care, and they're not going to care. It's really a Jim Jones kind of thing. And there are some people that probably aren't loyal to Turtle Boy, but still are part of that mindless mob because they bought into this so thoroughly that you can't convince them of anything. And so even here, I hate to say it, but the guy here that's saying that the feds only do both sides. I mean, are you following this case? The feds didn't find anything. Can you read that stuff? The feds didn't find any. Can you think that through? Or is it just you're so adamant here? Lisa says she's not mad. I just find it to be a distraction. Okay, I can appreciate that. So I can try to dial it back. Sorry. But sometimes I like to have a little bit of fun with it too. So hopefully that's okay. But I definitely don't want to make that the majority of the show. And we want to come to other cases after this. We can't, if this channel is going to continue, we definitely want to come to other cases. So, and we don't want to have fights. We want to be productive discussions from different points of view. That's all my life. That's been what I value the most. So, Tracy, thank you very much for the donation. And I guess we'll show that. And she said, much respect to you for seeking the facts, regardless of the consequences. And yeah, I mean, it definitely has not been easy. I lost friends, I lost my team, I lost everything related to anything that I've been working with on this channel. So, but you find out the truth about people when they're tested through a situation like this. That's how you find out the truth. And so it is what it is. But I mean, I stick to the truth. I follow the facts, I follow the evidence, and I don't worry about what people think. I worry about people thinking other ways, like if I'm, if Lisa's saying I'm being too fresh or something like that. Yeah, I worry about that. But in terms of following my analysis, that's not going to ever be affected by what the mob thinks or what's popular, Lisa says, I know what a mindless mob is. Okay, so then hopefully you can appreciate what I'm talking about. I'm not talking about everybody that has questions. We'll highlight Tom's comment. This is late for Tom, so he gets more creative. Joey, we are a distinguished group of intellectuals. Be gone, peasant. Nah, you can stay. Just don't be a dick. Joey, I don't think I didn't see all your comments, but I don't see you being a dick. So I'm not calling you a dick. I haven't seen that. But I wish you would. How do you lead people to the truth? I think the best way is really just to get them to process evidence more logically, but just start with yourself with one simple thing. Don't listen to anything that I'm saying about this case or anybody else is saying. Ask questions from both sides. Just recognize that in a situation like this, the defense is going to present you with a side. Okay, accept that. And maybe some of the things they say are true. But dig hard and keep asking questions of both sides. Understand that because much of what we're seeing, 90% of what we're seeing through social media has been given by the defense, that a lot of it is going to be distorted or a misrepresentation of the truth. The prosecution doesn't have the luxury of fighting through social media. They don't do that. So just have some common sense understanding that a lot of this stuff, that accusations that get put out there by the PR agent, Olivia and Aiden and stuff like that, that those things will be answered. They will probably be answered at trial, right? So just try to look at things from both sides. And Tom's getting exhausted, and I am too. My back's killing me, especially I did 2 shows yesterday too. So definitely too old for me. So I'll just skip to the very end, and then we'll call it a night. But thank you everybody for being here. So let's see, I'm all the way to the end. So Good Egg says, I need to know if the Fed investigation was started under Rollins as part of her political machinations. That would change a lot for me. Well, it was started when Rollins was still U.S. attorney. She was not ousted until last May. This thing was officially started in November of 2022. But I have seen the messages that know that Josh Levy was involved in at least August of 2022. So it goes way back. But yes, Rachel. So at the time, Josh Levy was the first U.S. attorney, which is second in command under the U.S. attorney, and the U.S. attorney was Rachel Rollins. And we know that David Yannetti is a colleague of Rachel Rollins who has worked with her in the past. They both had, not at the same time, but had been worked for the Suffolk prosecutor's office. Suffolk DA's office. And then, but in addition, there was a big case, big policy that she was trying to pursue to get the state Supreme Court to recognize and to change. And a lot of DAs were upset about it. But one person that wasn't and publicly supported it was Yannetti. And then we found out that Yannetti was also, I think, head of her transition team when she went in. When I don't know, I think her transition team, something like that. When Rachel Rollins was nominated to be the U.S. attorney, so there is definitely a connection there. So Joey says the autopsy photos look more like injuries from a fight. That's how we all look at it. Not just you, but me and probably everybody when we first looked at it without any understanding. But if you looked more closely, if you've been in a fight, I've been in a lot of fights, and your hands are torn up when you're in a fight. It sucks. It sucks. Your hand, every knuckle gets torn up, both hands. Punching a human body, when your fist strikes bone, it does damage. And your knuckles bother you for 6 months, a year. It sucks. You saw what might be a minor bruise on John's hand, or it might even just have been rigor mortis. I don't know, but you definitely did not see any scrapes on the knuckles. So John never hit anybody. And then, so all you had was the swelling on the eyes. But we know from medical experts that not only to testify, but many other people that we've talked to, that this stuff is there were crushed bones in the back of the skull that cause that raccoon look in the front with the eye swelling. That's what every medical expert says. So that swelling that made it look like he went through multiple rounds with Mike Tyson, young Mike Tyson, not 58-year-old Mike Tyson, that is from the broken bones in the back of the skull. So that's it. There's no other indications that he was in a fight. Yeah, the Durham report. Durham. I think it was actually Durham report. Durham. Yep, that's the one. More freedom. Thank you. Adam Hurst says, at what point do you think Aiden realized he was played? I can tell you exactly when it was. It was October, after he was released, or I know after his first court date, and he sat down with his new attorney and Bradel, and they were at a restaurant afterwards with two other people who I'm not going to name, but Bradel told something to Turtle Boy there that was powerful but inadmissible, that showed that Karen was guilty. So he's definitely known since then. And he just now, it's inadmissible, so that's why I don't mention it here. It's not something that will come up in trial. It's attorney-client privilege stuff. But he knows the truth. He knows. But he's linked his whole empire to this. What can he do? Here's a guy who literally expects his followers to call him daddy, which is only something that, like a Jim Jones cult, they would do. So when you expect your followers to call you daddy, you can't be wrong. You can't just say, oops, I got that wrong. No, you're daddy. You're infallible. You're the Pope. You're the Pope, dude. And you can't get it wrong. Tom says he was in a fight at my side at a food truck. Yep. Of course, I remember you were there. I accidentally kicked you, Tom. I dived over a hot dog. We used to have the lines were so busy at the bar that we had a hot dog guy, not connection to the bar, was set up outside every Thursday, Friday, and Saturday. He made a good living because we had such a big crowd out there. And a fight broke out, and I jumped over it to tackle the guy because he was throwing a punch, and I kind of half tripped over the hot dog thing, and Tom was jumping over with me or something, and my foot went back and kicked him in the face and left like a pretty big wound on him. I don't think that was the only fight you helped out with, but that was a funny one because it was pretty stupid what I did to accidentally kick you. But I don't know. You just react. But whenever Tom was an early guy, but whenever he made it to last call and we had the shit going on, he was always there to help me out. So I appreciate it. Just like he's here now, keeping the peace. Jules talking about the swelling, that it's bleeding from the brain. Yeah. From those broken bones. So, we don't know what caused those injuries. And let's end it with that. Let's talk about the injuries. And this is stuff that I've talked with my sources, and nobody can really figure out. None of us amateurs can figure out. But that's the key thing here is you're going to have to get professional accident reconstruction people, which according to Jackson, the feds did, but we haven't seen the report on that. And Jackson is a notorious distorter and misrepresenter, as the judge pointed out. So we don't know. But just looking at the evidence, we do know it is hard to picture, to understand how those wounds could happen. And what seemed to be a lack of wounds, we haven't seen the medical report. We just have some minor indications from it in the charging document and a little bit from the defense attorneys. But it is what we know now. It is a little bit hard to figure out how those wounds happened and the damage to the vehicle. So how did the wound end up on the back? Sorry, I'm getting tired, so I'm going to go back a little bit. But how did the wound end up on the back of John's head? That was, and so you have the wound. So if the car caused that, wouldn't that cause damage to his shoulder or his back? And we're told that there was no significant damage anywhere else. Now, there was in the charging document, there is a listing of trauma injury evidence in the pancreas. So that suggests he was struck in the midsection, but we don't know. And it also suggests there are possible signs of bruising on the picture there. But again, it's really, really hard to tell. And we're going to see more from the medical examiner's report. It's really the defense that said there's no injuries from the head down other than the scratches on his arm. And again, Alan Jackson is a notorious distorter and misrepresenter, to the point where it would be fair to say liar. But, let's go with the more accurate thing. He distorts and misrepresents. So, but we'll see. We don't know. And how could that injury be caused on the back of the head without doing significant damage to some other part of the body? Unless the injury to the head was caused by something else. So if he was struck in the midsection and his head hit back there, you had a fire hydrant, you had an old electric outlet thing, you had rocks and boulders in the mulch area. Maybe he had frozen. It looks like he ended up in the grass area. It was 18 degrees. Could frozen ground have done it? Could there have been a small rock there? I just don't know. And it is really difficult to figure out. So my theory was, for a long time, I took it at face value that what Alan Jackson was saying, that there were no significant wounds from the neck down. So based on that, I try to imagine what position your body could be in, that the car could strike your head, but you could not get wounds somewhere else. So it was hard. Like, so if even if you're sitting on the ground and the vehicle hits you from behind, isn't it going to do tremendous damage to your back? Isn't the bumper going to hit your back? Is it going to break ribs, break your neck? If it's from the side, if you turn like this, same thing. So let's say you're standing here and you go like this and the vehicle hits you. The vehicles might hit your head if you do that, but it's going to hit your shoulder and break your shoulder. So doesn't seem to be any evidence of that. We don't know. So the only thing I could come up with was that he had bent over to pick up his phone and he had a cocktail glass in his hand, so was trying not to spill it. And the car had swiped him. If you look at where the wound is, it's on the back of the head, but it's very close to the top of the head too. So you wouldn't have to be bent over very far. You could just kind of be a little bit bent over and maybe turn away as at the last second when you sense the vehicle coming. But I'm not standing by that theory. I don't know. I would guess I would probably go with Kate's theory that that he hit. I don't know. I really can't go with any theory. Nothing makes sense to me. So I can't wait to hear what it is. So I don't know. I alternate a little bit. I think Kate's theory was that he, she hit him in the midsection and then he hit his head on the back of the electrical box. But if that's the case, then he had to stagger away to where he ended up, I believe, even though we don't know exactly where he ended up. But if he staggered, how did the broken cocktail glass end up with him? Maybe if the glass broke during the crash, but it was a stem glass and part of it was still in his hand. Hey, I'm an Irishman too. That'd be my last instinct. If my last dying instinct would be to hold on to my drink. And I don't even drink anymore, but it would still be there. It's like ingrained into my head. So, did he possibly get hit and then try to get up and stagger a certain distance, still holding on to the glass? I don't know. To me, the more sensible thing is that the impact struck him, and whatever and momentum that put on him, where he landed, that's where he ended up. And so to me, I have to explain how that head wound is made. Either he landed with his head on something that cracked it there, or it happened in the collision itself. And the only thing I could make sense of was that he bent over to pick up. So let's say he's got a drink in his right hand, he's wearing jeans, and in his pocket is his phone. Now we know that Jen texted him at 12:29, and she called him, I believe, at 12:31. I could have that backwards. Maybe it was a call and then a text. I'm not sure. So if he's just got out of Karen's car, he's walking, and he's got his phone in his jeans, and then he gets a call, and he wants to answer it, and because he's got a drink in his right hand, he has to reach with his left hand. Now, if you've ever worn jeans and you have a phone, maybe back in the flip phone days, if you had it in your right pocket and you try to pull it out with your left hand, it's really, really difficult. And there's a pretty good chance you'll drop it, especially if you're drunk. So my theory was that he pulled with his left hand when she called him or texted him. He pulled it out, dropped the phone, bent over to pick it up while holding the drink in the right hand, and that's when she hit him. But I have no idea if that's true. I have no evidence of it. And, so, I mean, hopefully there's a better theory than that. That's all I can really say. If there isn't a better theory, there's probably going to be reasonable doubt, no matter how strong the case is. Now, I'm told the case is very compelling, but we'll see. And even just from what I know from the public evidence, it's compelling. Bob, thank you very much for the super sticker. I don't even know I had super stickers in there. How do I get a super sticker? I don't know enough about how this YouTube shit works. Fiona says she think he crawled. I mean, the question is, if John crawled, how did the cocktail glass end up with him? Did he hold on to the broken cocktail glass? Did he hold on to it? That was the key question for me. Where was the black straw was found? Was that found with the cocktail glass? So I don't know. Lori says he hit his head on a rock. I mean, that's the thing. So we tried to look into this too a lot in the last few weeks, and as best as we can tell, True Crime is here. Hey, Karen, nice to see you. So as best as we can tell, John ended up on the grass because the report is that he was on the grass and the snow around him had not accumulated. So if that's the case, was there a rock there on the lawn? Now, in the mulch area, which is a very wide area and is behind where the electrical outlet is and behind the fire hydrant, that there are rocks and good-sized rocks and boulders in there. So that would make sense. But how did he end up on the grass? If he was on the grass, maybe that's not correctly reported. We got the dash cam photo that I think it was Sean that released a few weeks back. And that photo looks like it's taken from the police cruiser as it's pulling up to where Kerry's SUV is. The back is open, and they're obviously trying to save John. But it's really hard to see anything in it. It looks like what could be a figure lying on the lawn in front of it, but it's really, really hard to tell how far on the lawn because there's snow there. is it on the lawn or is it in the mulch area? So it's really, really hard to tell. I think Jen McCabe's report is that he was on the lawn. But again, if he was just a few feet over and onto the mulch area with the snow there, so even if, say, 2 or 3 inches by the time Jen was there, could you really tell where the lawn stopped and the mulchy area started? I don't know. Comfort says, I think he was thrown and landed with the glass still in his hand and it smashed. Although keep in mind, a piece of that cocktail glass was found on the bumper. So it had to have smashed as part of that collision. Now that doesn't mean it didn't further. We don't know. We haven't even seen what type of cocktail glass it was. They come in all different types, right? So it must have at least partially broke at the collision, and then some of it stayed with him. Now, to me, I agree though with Comfort and Joy that if you're thrown and you're holding it, if something at high speed and with a lot of power hits you, and therefore puts on your body enough momentum to basically launch you, whatever objects are in your hand, that same motion, that same momentum is imparted onto them because they're in your hand when you're launched. So, if that object comes loose while you're in mid-flight, I don't mean mid-flight to just like he's up in the air, but just you're going backwards then that same momentum is on that object and it's going to go roughly with you, and it probably would end up with you. So Jules, I don't know what your theory is, so I'd like to hear it though. So Jules, can you post your theory here? Do you have a link to it that you've posted? No, I don't think I know what your theory is, Jules. So I'm tired. I'm willing to wait a few minutes if you can post me a link to it, or if you want to. Joey, why can't you see Jules' comments? Well, let's see. Jules is in. So one of you guys must have blocked each other. That's the only way. But so I will read it to you if she gives me the theory. Jules, either type in the theory or send me a link. Or if you want to, you have my other ways. You have other ways of communicating with me. So we have Facebook friends and we have Twitter friendship. I will keep my eye out for the next few minutes and see if you have anything. Let me just watch, give this a couple minutes and see if Jules has anything. So just to give people an idea, the number breakdown has been so weird on this. So right now, there are 1,300 people watching. And you probably don't believe that if you're on YouTube. So there are 1,137 people watching on Twitter, on our X-Vault Twitter. There are 68 people watching on my personal Twitter, which I don't even go on there. I don't even remember how I linked this. There are 0 people watching on Facebook, or 1 person watching on the Yellow Cottage Tales on Facebook, and only 92 people watching on YouTube. So the vast majority of people that watch my channel are on the Our X-Vault for Twitter, for whatever reason. Now, a lot of people will come and watch the YouTube over the next couple of days. So it's different. People go back and like to check and see, what we talked about. So yes, Tom reminded me, if you're over on Twitter right now, we're really trying to we need like another 80 to hit that 5K. So if you could do us a favor, and it'll only take you 5 seconds, just come over to YouTube and let me let's post a link to it. I don't know if I don't think I can actually post a link inside chat here. So I guess I can't do that. But come over to YouTube, please, and just hit subscribe so we can hit that number. A very small favor. That's it. It won't cost you any money. So just go onto YouTube and search for Yellow Cottage Tales. And right away we'll find that live, and then just hit subscribe for us. We've topped over 1,301 right now. Colin Forrester, 5% of me still thinks Richie hit him. Okay, so Richie was the driver of, this was Colin's theory, was that, Jules is going to make me work for it. Colin's theory was that there was kind of a combination of things of Karen backing into John, and then the truck that Ryan Nagel was in, not intentionally, but coming forward and then hitting John to add. So maybe that, I think his way was trying to explain the variety of injury, both on the front and the arm, and then the back. So I think he was trying to explain the head wound. All right, so I'll try to get to. I don't even know what's your Twitter handle, Jules. I don't think I'm probably going to find it because I don't know. Well, I have Messenger in Once Upon a Time, so let's see if we can find it that way. Looking through my messages. Once upon a time, I messaged Olivia to see if she wanted to come on. Yeah, I don't know how to find your Twitter, Jules. So, and I'm getting tired. I'm looking through here. I don't even know if we've ever communicated on Twitter. I can't find it. All right. There you go. All right. Jules just sent me on Facebook. So there we go. So you're about to get the theory of Jules. Let me put this on my other monitor. Oh, shit. Come on, Jules. It's the middle of it. All right. There it is. All right. So she says, if I had to guess, this is what happened on 34 that night. They're fighting in the car because they're both drunk and acting crazy. John wants to go to Fairview, I think she means, but Karen doesn't. John was likely laying back in his seat on the way over, so Karen is trying to convince him. Oh, that sounds interesting. I don't think you mean it that way, though. So Karen is trying to convince him just to come home because he's very drunk and should go to bed, but he insists on going. When they pull up, they're still arguing. And when Nagel passes, he only sees the light on and Karen in the car, and that's because John was laying back in the seat and had just pulled the handle to get out. That's possible, turning the interior light on, but hadn't raised his seat to get out. Karen is hands on the wheel, pissed as fuck that he's still going in. Hence the stiff 10-2 posture Nagel saw. Once John gets out, Karen rolls the window down and is probably yelling like, fuck you then. All right. So let's go to the next part of her thing. And starts to pull off. But John is pissed and whips his glass at the car, smashing Karen's taillight. Oh, that is new. I hadn't heard that. All right. So they're arguing, and when Karen takes off, she throws the glass at the car, smashing the taillight. She gets pissed and guns it in reverse, clipping John. He falls back and smashes his head on the curb or the frozen ground. Karen takes off. John rolls over onto his stomach and tries to crawl up to the house for help, but his brain... I just touched my cord. Hopefully I didn't lose... just making sure I didn't lose my mic. This thing is sensitive. So Karen takes off. John rolls over onto his stomach and tries to crawl up to the house for help, but his brain is filling with blood fast. He rolls onto his back and reaches for his phone in his back pocket and tries to call for help, but before he gets the phone fully out, he passes out with the phone falling underneath him. So, I mean, I'm interested in the idea, Jules. It's an outside of the box thing of throwing the cocktail glass at the car, but the problem is that the cocktail glass, or at least parts of it, and the pieces ended up with John where they found him. Right? So isn't that a problem? How did the pieces of John's car end up? I'm sorry, the cocktail glass end up there? All right, I'm on a different computer. I'll roll down to get the last page of this. Thank you for sending, Jules. Appreciate it. also explains the vomit in his pants, puking from the injury. So you got to wait. So let's look at the. So the big thing for me that you have to explain, Jules, is how the cocktail glass ended up with John on the lawn, to the point where the Canton police were able to find it because it wasn't buried in the snow anywhere, because it was in the grass where there was no snow, because John's body, so it must have been very close to his body, because his body kept the snow from accumulating in that spot. So what do you think? Is there any way that could see, if he throws his glass, then none of it ends up on the snow, right? I mean, I'm sorry, none of it ends up with his body. I don't see how it could. But I mean, I like the idea. Other than that, I like to think. I like the outside the box thinking a lot, because we never thought of that before, and there definitely seemed to be an argument there that could have gone something like that. So it's 11:01. I'm just seeing if anybody's. Okay, I'm looking back. So glass flies when shattering off an object. So Jules, are you still here? I'm just trying to see. I want to know, how did glass. All right, so that would explain the broken taillight, and it would explain how the glass ended up on the bumper. But it doesn't explain how the glass ended up near John on the lawn, how pieces of the glass, the cocktail glass, pieces that were large enough to be visible. I'm looking for answers, Jules. Jules, are you still here? Are you still here, Jules? Did your phone ring? Did you have to let the dog out or the cat? Does anybody else have any thoughts on that, since Jules might not be with us for the moment? Does anybody else have any thoughts on that? Anybody have any general thoughts on Jules' theory? Do you like that theory that he threw the glass at Karen's SUV? Do you think it matters that those pieces were reportedly found by the CPD in the area next to John's body? Anybody have a reaction to that? Anyone? Bueller? Anyone? I don't know. Are my comments being delayed? Suddenly there's no comments coming in. So there's a lot of people here watching. 1,300. It's up to 1,350 people now. So it seems like the later I stay on, it's just people get attached to it eventually. But most of them are watching on Twitter. Jules, you're still here. So tell us, how did. I don't know if you sent me a message somewhere else, but how did the cocktail glass end up on the lawn? The pieces of it. Fiona says she thinks he was holding it and blocked the car with his hand. I mean, one thing I've also agreed that I think there's a good chance that the cocktail glass broke the taillight. And the Free Karen Reed people seem to think that was a sign that I'm an idiot. I don't know. I mean, but to me, yeah, I might be an idiot. But if you have a fairly solid, heavy duty cocktail glass that would come from a nice place like that, and you have a car, a vehicle that's going 23 miles an hour, and remember, the taillight wasn't shattered all the way through. It was just the outer red plastic that was taken off. So it's not like this thing was crushed like you ran into a fire hydrant with it. So have you shattered a cocktail glass? Well, it should be kept in mind that I worked as a bartender, and then I was a bar owner. So I was in the bar industry for over 20 years. And the first place was a pretty rough place, and the second place was a very packed college bar. So I've seen my share of broken cocktail glasses. But I don't know, it would be an incredible coincidence, I think, if he threw that glass at the car on the road, and then significant pieces managed to find it, 20 feet away, 30 feet away, and end up next to him on the lawn, I think that would be a pretty big coincidence myself. But who knows? I mean, but your theory is fine because no one seems to really be hitting anything that works. Your theory is as good as mine. I mean, I don't buy it, but I'm sure I don't buy mine either. I don't really know exactly what happened here. So it's worth taking a shot at trying to find something here. And so maybe if you throw that out there, it leads to someone else saying, well, maybe not quite that, but maybe this, So, or like Colin's theory was that the truck that Ryan Nagel was in accidentally hit John after Karen hit him. Now, I don't believe that's the case. I believe that they would see that, and there's no indication of that. I believe that that truck left somewhere between 12:26 and say 12:29, and then John got out of the car a couple minutes after that. I think John might have been standing outside the car with the door open, and that's why the passenger light was on. I'm sorry, the interior light was on. And he didn't see John. Nagel wasn't looking for that. Who knows what he's half paying attention. And he glances over at some point while they're going by, and all he remembers seeing is the interior light on and Karen sitting there. In fact, it's even perfectly possible that John was just sitting there right in the car. And the reason that Nagel never said that he saw an empty passenger seat. Okay. What Nagel said was that he just never saw John. He didn't say John wasn't in the car. He just said, I didn't see it. I didn't remember it. All I remember seeing is the person. I mean, this is like, you could think any day on the highway. I drive by a car on the way to Boston, and you pass somebody, and the person that's in the driver's seat, you look over, and there's something interesting about them for whatever the reason, and you note that. But that doesn't mean the rest of the car was empty. You just didn't happen to note that. You just noted that interesting person that was in the passenger car that looked like Donald Trump or something like that. So it's not the same thing. Nagel did not testify that there was no one else in the car. He testified he didn't see anybody else, meaning he only saw Karen. It doesn't mean that he saw an empty passenger seat. So we don't know. So Joey, we'll make Joey in honor of I'll say hi to Benjamin John, and then I'll make Joey's question the end of this. So Joey says, Kevin, do you think there's any chance that he got beat up in the house? Absolutely none. And please understand that it took me many months to get there. All right. But here's the reasons why. The GPS shows very conclusively that John's phone never went inside the house. You can track. GPS is a location data. The chip that's inside that phone is designed. There's a chip that's designed just for one purpose, and that is to collect the one-way signal from the satellite. Satellites that are in orbit are there just for the purpose of sending out GPS signals. All right. It's the best and most accurate location system in the world. And it is very accurate. And it's clear when you look at that data exactly where they were, and they drove up down Cedar Crest Street, missed that turnoff, turned around, came back. At the same time, Ryan Nagel that truck was getting there, and she stopped briefly in front of the driveway and then pulled to the far edge of the property, and that's where John's phone was found. Now, GPS, there's a 15-foot margin of error normally. Occasionally, the signal gets weakened by something, and the margin of error becomes bigger, but that's indicated in the data when that happens, and it only happened for 3 seconds. So there's no question that John's phone went that path. He never got out of the car in the driveway and went in the house. You can see that. So he stayed in the car, and they went to the end of the driveway. Nobody saw him go in. That matches the witness testimony too. Nobody saw him get out of the car and walk into the house or walk up the driveway. No. So the data matches the eyewitness testimony. And so he went to the end, and he got out, and he never got very far before he got hit. Now, so the only way you could believe that John went in the house is that he dropped his phone, went in the house without the phone, got beat up and to within an inch of his life, and then they carried him out and dropped him on top of his phone. Now, what are the odds of that, right? Or what would be the purpose of that? You know, you even if you didn't know he dropped his phone, you could figure it out. Like if you called it, you might see it light up or something like that. Or, you know, or he might have come in the house and said, "Oh, I dropped my phone." But you're talking about, you know, what are the odds of them? Why would you even take him and drop him on it right on top of his phone? It's extremely unlikely right there. And then you add in the fact that the witnesses, all of them testified that he didn't come in the house. So right there, you're at about 99.9% that John didn't go in the house. And then you start adding, but let's just say, is it really one of the most elaborate conspiracies of all time, right? A cover up that involves multiple people having to stay silent from inside the house and other types of witnesses, and involves multiple officials that have to play some part in this conspiracy, but it definitely involves police officials having to plant evidence. That's what kills this in the end. And that's what got me to where I finally said, no, there's no conspiracy here. And that was before I had any sources. It was because the evidence, the way it was planted, for it to be planted, there was no access to Karen's vehicle. And now now we can look. This is what I knew back then, that there was no access to Karen's vehicle all day until it was towed. And so it arrived a little bit after 5 in the Canton police station. The main taillight piece was found by the CERT team at 5:45. You can see this very crowded street from the news footage with police officials and obviously at least one news truck there. So all that stuff, those things, those people would have had to get there plenty early enough to set up. So now you're talking about the trooper having to pry evidence under 24. That garage has 24-hour surveillance cameras in it, which has now been entered into evidence, by the way. So he has to race to the crime scene. The earliest he could get there might be what, 5:20, 5:25, with all those other police officials. If they haven't already started their search yet, they're getting ready to. They're setting up their lights. He has to walk out into the middle of that crime scene and bury those pieces of taillight deep because they were found buried. It just didn't happen. It just didn't happen. So, all right, let's call it a good night. Thank you guys for being here. Appreciate all the contributions, and let's just keep up doing the civil chat. Thank you very much for the theory, Jules. I'm exhausted, and somebody asked if I'm doing Friday. I'll have to find out more. I think it's Friday morning. There's a show. Yeah, we'll probably do it. All right, have a good night, guys.